Yes, call the list.
Lordship, the petitioner, Lordship, this is the matter of fixed for passing order, the appeal matter.
Oh. Have you got that judgment? I pass in the chamber, don't worry, today itself. I pass in the chamber.
Lordship, I am giving up 2 copies of the judgment.
Lordship, may I make one submission, Lordship?
Yes, yes.
Lordship, as per the order of the Honorable Court, Lordship, I have obtained a written permission of my client. She is willing to sell her Lordship.
Not
This is
affidavit?
in support of affidavit, Lordship.
Yes, please. No, that judgment is with us.
Yes, Lordship, it was given the.
Yes, yes, it is there. Don't give. Don't multiply. Yes. Call the next.
Let me, Lordship.
And it-
Lord, I am appearing on behalf of the applicant, Lord. Lord, I have received instructions that talks of settlements are going on between the parties. Lord, in that effect, I have received an email also.
Talk of settlement with the state government.
Lordship, I am for the de facto complaint.
Yes.
We do not, right? Lord, I beg to appear on behalf of the applicant. Lord,
What is this review? What
Lord,
is this
talk-
defect, sir? Review needs to be classified in words. We are not. Memorandum of review. Memorandum of appeal arising from an order. Review. But anyhow,
Lord,
what is the application?
Lord, I have instructions that talks of settlements are going on between the parties here. Matter can be amicably settled. Lord, I have received an email to that effect. My lord,
What
kindly.
was that matter? It was second appeal.
Yes, second appeal. Review
was
arising from
dismissed.
it was dismissed, arising from second appeal. Lord, talks of settlements are going on.
What is the other side? How can we understand that we?
Lord, I have received the email from my client to that.
The counsel for the petitioner submit that the parties are exploring the possibility of amicable settlement.
For I'm paying for short pass over. Dr. Arjun Chaudhary will be appearing in this matter.
No,
He's
you-
on his legs before the court
You are-
number 3, Lordship.
You are the Arvind?
No, Lordship.
Where is Vikas Singh?
Lordship, he is also on his legs before the court number 2, Lordship. I'm praying for short pass over,
I
Lordship.
think the precedence must be given to a division bench.
Lordship.
So what to do, madam?
Not today.
Lordship, kindly short pass over, Lordship.
Short pass over.
Praying for short pass over, Lordship.
Why short pass over? The city is pending at the order 41 still just.
We can. History.
Just communicate that the bench is waiting for him. They are sitting idle.
Lordship, the matter is
Let
going
him-
on,
let
Lordship.
him- Yes, so whenever he finds that he is now available,
Lordship.
no difficulty, we are waiting. Just communicate that we are waiting.
Eviction of a permissive possessor.
Yes.
So you are the licensee or something like that. And you have been evicted. The decree of eviction has been passed.
Yes,
No knowledge,
please
very-
just go and convince. We are just sitting idle, don't worry,
Lordship.
waiting for him.
The matter is going on, Lordship.
So we are only going on reading it, don't we? Yes.
You kindly make it short, Your Lordship. We will definitely do the matter, Lordship. The item number 21 is going on, Lordship.
Willing to come at 12.
Lordship. I'm great.
Let's call the next.
Document. Wait, then.
Let's call the next. This.
এই আমার লিস্টে চলে গেল নাকি? সাহেবটা দিয়ে দিল। ও বেলে চলে যাবে এবার।
Eighty, two, thank you. Four. Property counted.
এই ঠিক আছে আমি দেখি না আপনি
Yes. I remember it. It's called. Next.
Your Lordship, I am for the appellant. Your Lordship. 83. 83.
Yes.
Your Lordship, I am for the appellant. Your Lordship, affidavit in opposition has not been served. According to the last order, Your Lordship, the counsel for the state paid for filing affidavit in opposition. He has still not filed. Actually, Your Lordship may recall that his mother has died.
Whose mother is that?
Mr. Navankumar. He is the state counsel.
No, he is in 82. What about 83? We have called 83.
In 83, in 83, I am the appellant. He is the state counsel. Your Lordship.
Oh, Navankur Pal is for the state.
Yes, Your Lordship. He prayed for filing the affidavit in opposition, Your Lordship. Not been filed yet.
He is supposed to join today.
I'm not aware.
What's the matter about?
Matter, Your Lordship, can 2 was filed for appropriate order?
What's the matter about? Firstly,
Lordship.
tell us the fact.
I have no knowledge,
You are,
Your Lordship.
and you are arguing and you do not know.
No, Your Lordship, I'm the junior of the advocate on the court, Your Lordship.
Which order is under challenge? This is the order.
24th September.
This is the order. Original.
Memorandum is taken. First years.
No, this is the order. What appeal does. Yes, please.
So there is another appellate forum. Read jurisdiction is not the,
What, argue,
Your Lordship, not well aware of them.
you are not well aware, what are you talking, you are appellant, you said.
Yes, Your Lordship.
So you have to argue, this is the judge, this is the order you are assigned, you have assigned.
Yes, Your Lordship.
Tell us that why the appeal would be entertainable. How the appeal shall be entertained.
The advocate on the court is not.
Where is the judgment of Whirlpool? Mr. Mishra, bring that judgment of Whirlpool, find out. Whirlpool judgment of the Supreme Court. 1998 or 9. After the Whirlpool judgment, what remains? Satisfying, sir.
Your
You are-
Lordship may kindly
you are-
recall that the advocate on record, Mr. Arnab Shah, is out of station, Your Lordship. I have stated this is his matter actually.
So that is then it cannot remain pending for the all time.
Kindly fix the next circuit, Your
No,
Lordship,
go
because
circuit.
they have still not filed the opposition, Your Lordship. They are not.
Now, because
served.
of the change scenario, I am not very strict in dismissing now. But still, don't take an advantage of that.
If I had any kind of instruction, I would
What
have.
is this?
Your Lordship.
Whirlpool Corporation, I think that is a judgment. First of its kind. That is what I say, 1988, 99. At page 22. Look at that.
Arnab Shah went for his treatment,
Yes, Your Lordship, he has still not arrived.
knowing fully well
In the
that.
first day of the circuit, I have stated. Your Lordship.
So let me go back. No case in the circuit, so let me go back and enjoy there in the principal seat. Because everybody is out of station or something.
He has this medical condition, Your Lordship. As speech is down his throat, Your Lordship. Yes. The next matter also is his own.
So we are making some observation for the next circuit bench. That will do.
As your lordship dictates.
আমাদের বক্তব্যটা রেখে যাওয়াই ভালো। আমাদের বক্তব্যটা রেখে যাওয়াই ভালো। কোয়ালিটি ডিস্টেন্স একটু উপরে রেডি হয়ে থাকবে। আমার লিবার্টি দিয়ে আবার লিবার্টি দিয়ে দেবো যে আমার এখানেও লিবার্টি দিয়ে ফাইজ করতে হবে। Order pass হয়ে গেছে। This was for the phone and then registration, people look at it. Unnecessary life for me.
He has arrived at Jalpaiguri.
Who's the?
The advocate and the.
No, your lordship.
Who is this Shaib Akhtar?
I'm sure.
So you appeared on that day,
I have no instruction regarding the brief, your
but
lordship.
you appeared.
Yes, I appeared for asking for time, your lordship.
Take a decision. Let your kind make an alternative arrangement.
My next cycle will be all right, your lordship. He has gone for checkup. He is a cancer patient, as I have stated earlier also. The first day, matter of the first day.
Though Mr. Akhtar appearing for the appellant make submission. In matter,
No, it's not same, your lordship. There's a defective. I have to ascertain the defective over there.
you did not ascertain till now from 2024.
অর্ডারটা বার করুন।
আজ পর্যন্ত এটা দিয়েছে contribution. Where is the affidavit of service? Where is the affidavit of service?
It's not with me.
Yes,
It's not with me, Your Lordship. It has been served, Your Lordship.
where is?
Like, presently, it's not with me.
It's not
but-
with you.
But I can. So, Your Lordship.
Section 5. I'm really surprised. Move in the right direction.
Yes, Your Lordship.
You are moving from a post to pillar. Please move in a direction of pillar to post. Admission of appeal and thereafter condonation, no. First is the condonation, then admission. To be careful when you draft. Yes, because of the illness of the advocate and record of the appellate. Who has gone out, who has gone out of station for his medical checkup. Let this matter be listed.
Lordship, item number 85, Mr. Ankit Kanodia is appearing.
Lordship, I appear virtually.
Can what?
Lordship, I appear virtually. Lordship, it's a stay petition. Lordship, the GST matter.
Let us see, just 1 minute.
Lordship, the impugned order is.
Where is the certified copy of the order?
Lordship, this certified copy, Lordship, it was filed with the leave of the court. And Lordship, what has happened?
It was, the certified copy was not filed.
No, Lordship, actually, I'll just, Lordship, take one.
You sought for a leave without the certified copy.
Lordship,
Leave
but
was
what,
granted. Now,
Lordship,
where is the certified copy now? I'm
Lordship, this file was transferred to Calcutta. Honorable Justice Rajvi Kishan Kapoor had delivered this judgment from the circuit, from the principal bench. Then we applied in the principal bench. Now, when we applied in the principal bench, they are saying that it will take some time. It is already applied for. I have the acknowledgement slip, Lordships.
Where is that, sir?
Lordship, I have not yet got it, Lordship. I will, Lordship, because of the
Have
file.
you read my judgment on this very recently before coming to this circuit bench?
Lordship, I apologize, Lordship. I have not read, but
You
Lordship,
have not, that is what is, because I have been very strict in this regard.
Lordship, I will.
If you have
Lordship,
obtained a leave to file without certified copy, then you have to show that the certified copy has not been made ready as of now,
Lordship.
or you have already obtained, then you'll have to file it.
Lordship, I have the acknowledgement slip, Lordship. I will just inquire today because, Lordship, because the file being transferred from Calcutta to Jalpaiguri again.
Why you did not annex this copy of this application along with the memo?
Lordship, it is there, Lordship.
Lordship, it is there. The acknowledgement, the
It is there,
receipt is
Lordship,
there,
at the last
Lordship.
page, Lordship.
It is there, Lordships.
Yes. Eta kaaj karo. Call the registrar and ascertain from the principal seat whether this application is still alive or it has lapsed.
Lordship, may kindly give me 1 day time. I will get it.
Just
I will
it
inquire.
be different. Yes.
Lordship, may kindly pardon me for this.
Come tomorrow, give a report. Give a report on this.
Lordship, may kindly, Lordship, this was the first time, Lordship, I got your point, Lordship, with due, Lordship, I apologize for this delay, Lordship, but Lordship, just
Mr. Counsel, I have delivered a judgment on that.
Lordship, I will go through.
Yes, you have taken a leave, no doubt.
Lordship,
You have to make an application for certified copy
Lordship,
within the period of limitation provided for filing an appeal. And then if you do not file the certified copy on the basis of that particular application for certified copy,
Lordship,
then even if the leave which was granted, your appeal would be regarded as a time bar within the meaning of section 12 of the Limitation Act.
Lordship, may kindly give me 1 day's time. I will.
So we experienced at the principal seat that the application for certified copy which you annex, it is found that you never filed any requisites, nothing, and that application lapses. Then the fresh applications are filed to obtain the certified copy. We say that it is a time barred one.
Lordship, may kindly excuse for this time, Lordships.
So
I will.
tomorrow come, we will ascertain from our department
Lordships,
Whether, what is the fate of this application for certified copy?
Lordships.
If it is still alive, no problem. If it has lapsed, then there will be a problem for you.
Lordship, may kindly grant some time, Lordship. I will try
You
my
need
best.
not come tomorrow. We will get the information. Don't worry.
Lordship, I will
Need
also
not.
try
We
today
will
from
get
the
an
principals.
information from our department. Don't worry. We have
Get
already
good.
started to get a report from there. Is not today. We'll take up tomorrow.
Grateful to your Lordships.
Yes.
The appellant. Appellant.
Who is the applicant? Deborshi Dhar, Devjit Kundu. Oh, he's from, it's an education matter. You are for the state, education matter. It says care of Ikramul Bari, that means an education matter. Where is Sikh Imtiazuddin? I do not know. Passover. I'm not dismissing now. Anyhow.
My lord, I am for the petitioner respondent.
Petitioner respondent means what petitioner? What respondent?
Original petitioner.
Writ petitioner.
Writ petitioner.
Writ petitioner respondent.
Yes.
Who is for the appellant?
I presume Mr. Deborshi Dhar.
His name, her name is, or his name, I do not know.
The Dipanjan Dotto will be appearing via online, but as I can see that, please kindly give a passover.
What is this?
Supposed to appear on the online, my lord.
Where? Where he is?
Lordship,
Isn't it? Lordship, the advocate, Dipanjan Datta is in his late before the court number 35 in principal bench. Kindly give it the passover. He just give me the information. Kindly for passover. He will appear, my lord.
He's already on legs. How can he give you intimation?
I just follow that just mobile, check the mobile that he just sent me the
While
message. I
arguing,
haven't seen.
while arguing, he has given you an SMS.
He probably sent it me back earlier, but I haven't seen that. I just
When he is on, not on his legs. At that time, he said this message. When he was
he
sitting.
just instructed me, my lord. Kindly short passover. He will appear.
Is there any stay of the operation?
no, my lord.
No,
my lord.
then you are happy. We are keeping it next circuit. You have
My
been
lord,
reinstated with full back wages.
No, my lord.
That's up to you what to do and what not to do.
Yes, my lord, I understand, my lord, but actually A respondent is suffering for so long from since
Sir, that is
2021.
what I am saying, that it is up to you who has to take a decision.
Yes, my lord, I can understand.
So take steps, whatever they want.
My
to
lord,
make a
another
judgment,
thing
let
is that the affidavits have been exchanged. The matter is only left for hearing right now. My lord, last time, what I can say, yes, sorry.
You did not take any steps.
My lord,
There is no stay order,
yes, notes there.
so you take steps
Grateful, my.
and that will.
And accommodation is sought on behalf of the counsel for the appellant.
Uncle Bali is appearing on behalf of the appellant, my lord.
Competent.
My lord, 88 Novankud Bali is appearing, my lord. His mother's Sraddha ceremony is on 14th.
Hey, the order is passed করেছে না, bereavement mother expired, so next circuit.
Well, I'm for the appellates. Well, there's a delay of 28 days filing this instant appeal.
Who is for the respondent? I am for the.
Again, one is the delay.
Just one. You are appellant.
But,
Tell us why you are aggrieved by it.
first of all, the work in respect of which the payment has been made allegedly, that work.
Are you a issuing authority?
My lord,
Are you an issuing authority? Are you? Or it is the private
Well, it
former respondent who is the issuing authority?
my lord, the issuing authority.
Payment, who will make the payment
Well,
of the amount?
It will go from.
Who will,
Well,
it will be paid by this Tamang Development and Cultural Board,
yes,
who has issued the order
Yes.
who has entered into a contract,
But there's no such contract, there's no such order.
whatever, the work which is done and the payment is to be made.
Well, there was no such order.
Who?
Well, there was no tender floated for the work.
What are
that's-
you talking about? Then how the money is
Well,
gone?
well,
Earlier, the amount was paid. This time the
Well,
amount
that
is paid.
Well, that is why this is, the order has, in the order, it has been directed to the principal secretary of the tribal development department to
What?
make the payment. But kindly has a look at the impugned order.
Who are, you are a state, sir.
My lord.
I am asking you, sir, if they come forward, I can understand.
My lord.
Who are you?
My
You
lord.
have not issued a check.
I have been directed, my lord, that is the problem.
What? There is no direction.
Yes, my lord.
This the direction is the principal secretary,
Yes.
tribal development director.
Tribal development department, that is
Correct.
state, my lord.
What is the state?
My lord,
What
The
are you
principal
talking
sec-
about?
my lord, the principal secretary tribal development department is the department of the state, my lord.
Department of the state.
But it's not the board, my lord.
What?
Well, it's not the board which has.
It's not a board.
No, only the direction has been issued upon the principal secretary tribal development department,
And who is representing the trouble, this,
board,
the West Bengal
Tamang development.
Command Development and Cultural Board? Who is
We are
representing?
not representing.
Why?
It's an autonomous board. They have separate councils, I believe, because
Yes,
they have separate councils, I believe. It's an autonomous board.
autonomous. From where the money comes to them?
Well, the money is they place the bills in before the tribal development department, and from there the money comes. That is
I just wanted to know that what is the source of the income of the board?
well, they
Is the state who provides the money?
Yes.
Or it is they have self-generated amount or a money, is they do it?
but they also receive grants from the state as well as they generate independent revenue.
So if this order is modified to the extent that they will pay the amount, that would do?
My lord, the thing remains that would do, my lord, in first
So-
instance, but the thing remains that
First instance, I am talking about when they issued a check, they were satisfied that the work has been done
Well, what
for
is
this
being-
amount. Who
what
are
is-
you to say
what
that?
is being
I'm just
suspected-
asking you.
because this Tamang Development Board works under the authority of the Tribal Development Department. Is the department which oversees.
Have you raised any issues to the board that why you have issued a check?
My lord, that communication, my lord, that has been done, but the thing
Where
remains
is
that the
that?
board is. My lord, the board is-
Where is the communication? You
My
did
lord,
not
what
produce
we-
that before the
my
court.
lord, kindly goes through
Single bench.
my grounds of appeal once.
Grounds of appeal is not supported by any affidavit, sir.
My lord.
I want a statement made on affidavit. The board is an issuing authority.
Lordship,
He has issued a check.
yes, my lord.
The bank says that one of the authorized signatory, which is recorded with them, has not put the signature. So this was not honored.
Lordship.
The single bench has said that previously also the same issue was raised, but later on that check was honored.
Lordship.
Bank
There were
has
two checks, in fact,
credited.
one was credited.
Bank has
It's a
credited
subsequent
to
check.
their amount. This
Yes.
time also this cannot be done. So you were directed, since you are having a control
Lordship.
or a supervision over the
Yes,
board
yes,
functioning,
yes.
you were directed to remit that amount to the board so that the board will remit
Well,
the
the
amount.
thing remains that the work for which this payment has been allegedly made, no tender for that work has ever been floated. And the beneficiaries under this housing project, they were directly, it was sent by direct benefit transfer to the respective accounts of the beneficiaries. So the question of the board engaging any other contractor, the writ petitioner concerned, does not arise at all. That is what we are basically disturbed with. That is why we have preferred
So
that.
why have you suspended the board?
We do not have direct.
You do not,
authority.
you have a control, you can regulate, you can monitor,
Yes, ma'am.
you can put the board under your surveillance.
Well,
The board is constituted under your aid,
well,
the AGs. And you are providing a grant. if the board is doing something
I
which
did-
is contrary to law,
Yes, my
will
lord.
you not take a step?
Well, I intended to file an affidavit in opposition before the read court, but that also I couldn't file the affidavit in opposition because the order was passed in this manner. But kindly directs the.
Where is your prayer that you wanted to file your opposition?
Well,
Does
there
not
was-
appear to be so.
I believe.
It does not appear
because
to be
this is
so.
this is the order that was passed, my lord.
I am asking you, sir, Mr. Mominur Rahman,
Yes,
Mr. Sumit Kumar, both appeared.
Yes, my lord.
Not a single whisper I could get from the order.
No, my lord, but
that,
this
you
order
asked-
was, my lord, if my lord directs, setting aside this order, if my lord directs the read court to take up this matter on merits by hearing, by allowing a chance to file
Simply on
affidavits,
the-
my lord, then it-
Simply, let me see the law, sir. Let me understand.
my lord.
Simply the appellant thought that the order should be set aside. The court is bound or obliged to set aside the order.
No, no, my lord, no, not at all, my lord.
If this is the law, we have to learn.
No,
from
no, my
it.
lord. Not at all, my lord. My lord, the thing
Show
remains
me
that
the
allow us.
ground, you have raised certain issues.
Yes,
Show me that first thing is that you asked for a opposition to be filed, rejected, court proceeded, I will accept it. Does not appear that you have done. If you think that certain events which is recorded or not recorded in the order, then you'll have to approach the same learned judge to say that this is what I made a submission, that submissions must be recorded. You did not approach.
Lordship.
Now, for the first time before the appellate court, can you take a particular plea which is based upon the fact? And it does not germane from the record that that fact really exists, what to do?
My lord, the issue that is involved is.
Again, I am talking, you were there, you
Yes,
would have
I
raised,
was there. my
it
lord.
does not appear that you have raised those issues. Can you prevaricate your stand at the appellate stage?
My lord, I bow down to whatever your lordship has said,
So-
my lord.
Sure, we are
Well,
ready to
we-
accept
we
it. No
appreciate-
difficulty.
My lord, what the appellant seek is that is a fair payment if made, that is what we have filed the appeal for. Because if the payment is made to an entity who has not done any work and he
No,
receives the payment.
no, sir, please, what I gathered from your submission, I think this submission is absolutely mutually destructive. At one go, you said that the board never issued any tender nor any followed anything and is
No, my
done.
lord, no, my lord. If that is true,
Then at the second breath, you are not supposed to say that they did not render any work, they did not do any work. How the money will go to it?
well, the board did not issue any tender. That is why they could not
Sir,
have done.
that
the
is
work.
one thing, that's the procedural aspect.
Yes, my lord.
But the second thing is that the work has been done.
But not-
Money was due, you say that no work was not done. These are the two
This-
things which
They have not. done
appears
the
to
work.
me is mutually destructive.
But they have not done the work. That is my contention.
Where is your contention? Where is, nothing is there.
Why did they pay for the first work? If there was a procedural error, I did not do any work. So why was the first check ordered?
Correct. For the same contract,
And even if.
please, for the same contract,
No, there was. work
No,
ordered.
there's two different. One is for the housing scheme, another is the toilet
Even if-
scheme.
whatever.
Even if. a
If there
tender
was
is
no
not issued,
tender, how you have honored that?
I am still entitled to payment for gratuitous, non-gratuitous work according to the contract act. He has done a work and it has been admitted by the board.
The board has admitted and was satisfied that you have done a work. That's why they issued a check to you.
That's right.
How can you now say that? How? Tell us how.
Well, what I have already stated, I cannot go beyond that.
So what mere statement will not do. Then why you have honored the first check? If it is a.
Well, it's the board which has made payment of the
Then,
first check.
then it is a.
And
board
that
who
was
has to
also
make the
beyond our
payment.
knowledge. And this is the second, when this second check payment was being made, that came to our
And
knowledge
it
and
was
that is why.
not that, please kindly consider, it is not that you raised an objection. It was not. It is only when a bank says that there is some discrepancy in the check. I cannot honor it.
I bow down to whatever.
You came in a picture the moment the writ petition is filed.
Lordship.
And the moment you find that these are the things going on, you have not taken steps as on this day against that board.
Let the subject to correction.
You have not taken any steps.
Well,
Since there was a direction, you are. And now, when they say we modify the order, you are also happy, let them make the payments.
Subject to correction, the principal secretary is not directed to pay. is directed to take
Ensure.
necessary steps and ensure. Payment has to come from the fund of the board.
Well, the board is going to ask from the department.
Oh, it was a check which is issued by the chairman is credited in the account.
Yes.
The
There was no direction
direction
from
was
it.
not upon you. Yes, it was not upon you.
Well, the principal secretary tribal development
Yes,
department is directing.
ensure and see that the check which is there is credited.
Well, the check was
If
not.
the check is not issued by you, but
No,
only,
it is
only thing is that you have to ensure.
But how can we ensure when we
Ensure
dispute-
that any person who has not signed, you will see that put your signature there and there.
Well, we dispute that said check, in fact, that is the
Sorry,
problem, how can
Sorry,
we
that-
ensure? Mal?
That cannot be done.
We dispute the entire because this.
We will record your functioning and your conduct in the order.
My lord.
When you come, we will record.
It does not require any allotment of fund from you, your side.
It requires,
No,
but
no,
the
it
funds
is
is
a
to come
grant
from
which
my
is
side.
already given at the first, as
Yeah,
per the
first.
budget. And then they undertake all those works and then they issue. This is an independent board, autonomous.
When it's
Autonomous
budgetary terms,
board.
it would be non-tax
That's true.
funds. Non-tax funds.
So that is
So
why I
what-
say, since you
The
are
financial
monitoring,
burden is on the state, that is why, my lord, I said.
is within the grant,
But the,
it is within the grant.
but what we mean to say is that if the
Sir, what you mean to say, we understood. But what we mean to say is not understandable to you.
my lord, I bow down to whatever your lordship.
That is what is the problem. If you have seen a particular body which you, the birth of which is through you,
My lord.
is not functioning properly.
My lord.
Is it not expected that you will come up and take some steps against?
Well, that is required.
You have not
I bow
done,
down, that is required because
you have not
we
done anything till now.
definitely suspect that something not
You have
proper
not
is
done anything.
not
And
proper is going
now,
on.
now, in the first go, it was honored, no objection.
That was, we ought to have taken steps after we have come to know that,
So-
that I bow down to that.
Why you have not taken steps?
Well, that
And
that
then
department ought to
a
have. taken
person
steps.
who has genuinely worked, the board who is monitoring the whole project, if they are satisfied that the work has been done, a third party who was sleeping in a slumber after being awakened, or he woke up and say, no, work is not done without going there.
No, work has been done, my lord, but the work which is concerned
Now
here,
I can
it's a direct benefit for transfer work. My
No,
lord.
no, that
No
is,
agency-
understand.
No agency was engaged for that
Anyhow,
purpose.
let us come. Because let them do
Item number 4.
Item number 4.
Lord, the appellant before your lordship, my lord, was the defendant in the trial court. My lord, the plaintiff had filed a suit for eviction,
Recovery of possession.
eviction and recovery of possession.
Eviction is under the West Bengal Tenancy Act.
No,
Recovery of possession is under the General Act.
Lord, the plaintiff says
Everybody
that
use this eviction so loosely. Eviction is always under the Special Act. And recovery of possession is under the General Act. Say from permissive occupant, from lessee.
my lord, it was their case that I was a permissive possessor. And after the lapse of the requisite time, I was not giving the khas possession, and as such, my lord, the suit was filed. Now, my lord, the very first point, my lord, that I have raised before this honorable court is that the plaintiff, she was the constituted attorney of the owner. Allegedly constituted attorney of the owner.
First issue was whether the suit is maintainable in the form, you did not press that issue.
Lord, that is one aspect, but I'm coming to that.
You have
I'm
to
coming to,
answer, sir,
yes,
you have to answer.
yes, I'm coming to that.
If
Lord.
you did,
But
if you
I-
not press the issue, then can you raise that issue at the appellate stage?
No, my lord, but I had made submissions. I had made submissions to that effect. I will show that to your lordships. That the plaintiff, who was the constituted attorney of the original owner, now, my lord, she says that she has been granted power to institute the suit wide a power of attorney executed by her husband. But, my lord, that power of attorney was not exhibited in the trial court, and the very locus.
That is why if you abandon or waive or accuse the particular point, can you raise it for the first time?
No, my lord, that was raised before the trial court as well,
No,
because
it was
submissions,
not pressed.
no, my lord, not with respect to the maintainability, but
That
that
is what it strikes at the maintainability of the proceeding.
lordship.
A constituted attorney is not entitled to institute a suit.
Suit. My
So
lord, such
if
submission
you
has been
abandon
made.
that issue, if you abandon or accused or waive the issue, can you raise it?
My lord,
for the first time?
I have not, because I have made such submission and that has been recorded by the learned trial court. That this submission has been made at the time of argument, and as such, my lord, that was not at all considered, because she says, the trial judge says that a power of attorney, photocopy of the power of attorney has been produced, and that is sufficient.
I am asking you
Lordship.
that the appellate court has, I have read the judgment of the appellate court.
Lordship.
So that's why I am asking you, where is the finding of the trial court in this regard? Where is the judgment of the trial court?
My lord, that will, lordship will find that in the stay application.
Yes.
Now, my lord, page number 39, running page number 39, internal page 17 of the trial court judgment. The third paragraph from the bottom.
Yes.
But it says learned advocate for the defendant number 1 and 2 submitted that the plaintiff has no power to file the instant suit on the basis of the said power of attorney, as the plaintiff's husband is deaf and dumb and is not able to execute the same. But this point did not raised in written statement.
Referendum does not mean that he does not have the perfect intellectual ability to take a decision.
Lordship. But the same has to be, my lord.
Only thing is, he cannot speak or hear, but he has the perfect intelligence.
Maybe, my lord, maybe. But
Maybe.
no, my lord, that thing, my lord, the evidence has to be come on record, my lord.
Why the evidence is required if it is not going out striking at the root.
Now, my lord, the document is a notarized document.
Sir, please come to page 32. First issue.
Lordship. I have read that, my lord.
So what is the meaning of this word? The plaintiff filed this suit for eviction of permissive possession. But at the time of argument, this issue is not raised by their lawyer.
Lord, this is contrary and in contradiction to my submission in page 39.
I am again asking,
Lordship.
sir, if you have not pressed the issue, then what is the impact of the same?
Lord, I have pressed the issue and that is not evident from the submission I have made in page
Then if
39.
there is the wrong recording of an event.
Yes.
What is the court open to you under the law? Can you raise this point in the first appellate court?
No, but beloved, both the things are evident from the judgment itself that I have submitted this before the learned trial court. The learned trial just says so. And he, Lordship,
Okay, but if you abandon the point and thereafter you argue for from another point, then what to be done?
but Lord, the issues are Lord, connected, interconnected, and issues are interconnected because that is the issue, Lord, I am pressing before your Lordship today.
Suppose if there is a power of attorney is not exhibited.
Lordship.
Does it disentitle the plaintiff as constituted attorney to institute the suit?
Why,
I'm asked,
why?
if the court,
No, Lord,
Otherwise-
particularly when the defendant has raised an objection with respect to the genuinity of the power of attorney.
what are you
Okay,
talking
okay,
about?
just-
Who are you to raise a question on genuinity?
But Lord, that has to
The
be proved.
principal who has executed can raise a question on genuinity. Third party will say is a genuine or not.
Lord,
genuine.
that has to be proved. because-
Why it is required?
Lord, whether she has the locus to file the,
Why not? As a constitutional attorney, she can institute.
Lord, that document has to come on record.
Whatever, if the court has found that it is there, then why not? I'm asking, where is the law which says that it cannot?
And another thing that it has been recorded in,
Lord, there is a
Page
very
number
recent
39.
judgment of the honor, not recent, 2023 judgment of the Honorable Supreme Court, where my Lord, their lordships, my Lord, have differed in opinion. His Lordship Justice
That
Emarsh,
is a different one. You are talking about Justice Ravindran's judgment.
no,
of the
Justice
Supreme Court.
Emarsh and Justice Bibin
I'm
Agrawal.
telling you, the
Yes.
Justice Ravindran's judgment was the first of a kind, where it says Justice Ravindran was of the view that the constitutional attorney is not permitted to lead the evidence.
Yes,
But their lordship says in the Supreme Court judgment that there is no fetter in law that the constituted attorney cannot institute the suit as constituted attorney if the principal does not come forward and challenge it. What was there in the judgment was that whether he can lead an evidence in proving a particular fact which is within the
Exclusive
special knowledge of the principal. The question was, no, it's the principal who can only lead an evidence.
yes,
Which
yes,
is within the special knowledge
of the principle.
because of section 106
Six
of
of the Evidence Act.
the Evidence Act.
Yes,
But later on, it says that whether the power attorney who has not been given who has been given a power to present the deed for registration of a property can execute the deed. The question was no. There was divergence of opinion. This has been referred to a lawyer.
yes, yes.
On the basis, it was only for presentation, whether he is supposed to sign.
No, but under what circumstances, my Lord, this power of attorney, the registration of the power of attorney, as well as, my Lord, section 33 of the Registration Act, my Lord, came into play. My Lord, the entire law on the point, my Lord, has been discussed by the Honorable Supreme Court, but I am
It's
not
the
relying on
institution
that.
of the suit, recovery of possession,
Lordship.
from a permissive occupant, the wife being the constituted attorney is aware of all the events that has taken place.
Now,
Nothing
my Lord,
but-
even for the sake of argument, my Lord, even for the sake of argument, my Lord, the wife says that his husband is the person who has granted permissive possession. My Lord, for the sake of argument, let us assume that is correct. So, my Lord, that is within the exclusive knowledge of the
No,
husband.
no. What are you talking about? The wife is present at the time the entire transaction has
My
taken
Lord,
place.
that is not there in the
I'm
evidence.
again, then whether that will be regarded as a special knowledge, what are you talking about? Secondly, it is a suit for recovery of possession against the permissive occupant who is already there in possession without any kind of a title in support of it. Sir, you have taken a plea of adverse possession. What does it mean?
No, my lord, I have,
What does it mean? You have, that's your defense, sir.
lordship.
That's your defense. So that's, you have to prove it, that you have perfected the title by way of an adverse possession.
My lord, I have exhibited documents showing payment of rents to the government, my lord,
Does
since
it
long.
mean that, that your position becomes adverse? I think in order to succeed on the ground of adverse position,
Lordship.
there are 5 elements which are required to be
Lordship,
proved.
that is right.
2009 Supreme Court. I
Lordship.
And you did not take up this issue of power of attorney in your written statement also.
Yes, in the written statement, I have not taken, my lord, that
Then-
that is a
then-
fault on my part, but I have argued
Fault.
that, I have argued that, my lord, and the trial judge has recorded that in the judgment.
Can an evidence be given without any pleading? Can the court look into the evidence for which there is no pleading? I am asking you. Tell us.
Basic principle, sir. Without pleading, how can it be?
This is more better case, I put it to you. The worst case is in your scenario, can a plea of fact be taken for the first time at the bar when there is neither an evidence nor the pleading? It's a more worst case. I give you example of good case. That there is an evidence which is given by a witness, but there is no pleading. Can a court look into that evidence? Judgments are no. And this is more worse. No evidence, no pleading, at the bar argument.
Lord, that is right. What your lordship, what is falling from your lordship is correct, Lord. I understand that. But, my lord, since the issue involves, my lord, the locus of the plaintiff, and my lord, she says that my husband had granted permissive possession. She did not say that I was all along present throughout the transaction and I am aware of the
Is it
factual.
necessary? Is it necessary if she say that the husband has given you a permissive occupation? In turn, you says that no. My position becomes adverse to your husband. I have perfected the title by way of adverse position. And what about your evidence itself also? DW1, you admitted everything that the husband, yes, he is the owner. The husband who gave me who put me in position.
And
That's your own evidence, admission.
no, my lord,
Can
my
you argue
admission
with-
does not
define that.
My lord, my
At the bar.
admission, my lord, it is a settled principle of law that the defendant's admission does not, my lord, makes out a case for the plaintiff.
No. I think you have to reframe it.
My weakness.
No, it is the weakness of
Of
a
the
defense case will not inure to the benefit of the plaintiff.
Yes,
Because the plaintiff has to prove his own case.
lordship.
It's a weakness. It is not that the admission.
Yes, my weakness, my lord, that is what I was.
That's your own admission. That will go. It has,
No, but she has, my lord,
demolished
the
everything.
plaintiff has to prove, my lord,
what
independently.
are you talking about? He has proved that I am the owner. You admit, yes,
Yes,
he is the owner.
when you are,
What? Is he required to prove it?
when you are
When you
admitting
do
that
not dispute.
you are setting up plea of adverse possession, that means you indirectly admit his ownership. That is the problem.
Is the second level. Here you have clearly admitted the plaintiff is the owner.
So, you are setting up adverse possession, so indirectly you are admitting that he's the owner.
Now,
He's
my
an
lord, another thing and the most important and vital thing is that this food property was an unpartitioned plot. My lord, the defendants,
all these pleas have to be taken.
it was taken, my lord. It was taken, considered.
Let us see. Koto height is jete padoti. Yes.
Height
yes.
of certificate.
Undivided property. Yes. Let us see.
Lordship, that
Undivided property. Now tell.
now, my lord, the other defendants, my lord, the other co-owners, my lord, those co-owners, my lord, they have not contested, the suit. Now, my lord, due to misjoinder, my lord,
Can anybody who is there, Sriram Pasricha's case and Kanta Goyal's case of the Supreme Court, way back in 1950s or 60s. Sriram Pasricha and Kanta Goyal. These are the two cases of the Supreme Court against you.
Misjoined and non-joinder.
That one of the co-owner is entitled to maintain a suit for recovery of possession. Other co-owners need not be either made a party, nor the only exception is if they come forward and object that no recovery should be made, then and then only you can have, otherwise not. Sri Ram Pasricha and Kanta Goyal. These are the two judgments.
my lord, allow me to, my lord, go through the judgment.
Not necessary, it's to settle the proposition. I anticipated what you will argue, that's why I requested my brother not to let us see that how far you can go. Find out that two judgments of the Supreme
My
Court.
lord, I will go through it and my lord.
It's
if
not
something-
necessary, I will give you. Can anybody find out this?
My lord, I can,
And the previous one is Sri Ram Pasricha. Give that Kanta Goyal also the same principle. I think Sri Ram Pasricha must be considered there. That's the first foundational judgment, Sri Ram Pasricha. Kanta Goyal is of which year?
Yes, my lord, network issue.
1977.
Sri Ram Pasricha is just before that.
BP.
I have on the way, but it's this one.
The same principle.
1977.
Yes. Same principle.
This is Krishna. I have.
You settle the proposition. Third point.
Now, my lord, since I have been, lordship has already held that since I have said it in my evidence that the land belongs to him, so that amounts to my admission. But my lord, at the same time, I have also adduced evidence that I have been paying rents to the government of West Bengal since long, for the last 40 to 50 years, and those documents, my lord, have been exhibited. Those documents have been exhibited before the learned trial court. Now, my lord, the plaintiff did not come with any counter evidence that I was not in possession of this food property.
You
or
are in position, that's why the recovery has been sought.
Yes, so my lord,
Please
for the
kindly consider when a suit for recovery of possession is filed against a defendant,
lordship.
then one thing is admitted by the plaintiff that the defendant is in possession.
Yes.
So that's why your possession is not disputed. That's why they want a recovery.
So, my lord, that is where my lord, the difficulty is. The plaintiff says that for the last, prior to filing this suit, 10 years prior to filing this suit, my husband has given the permissive possession to possess the land. And my lord, at the same time, I adduce evidence that I am possessing the suit property for the last 50 years, and my lord, exhibit documents, the rent receipts given to the government of West Bengal. So at the same time, the evidence adduced by the plaintiff, my lord, becomes doubtful.
Doubtful.
And at the same time, my lord, the argument placed by me that the husband, the owner, co-owner, my lord, had to come in the witness box and had to depose whether this fact is correct or not. So this evidence, my lord, had to be adduced by the husband in view of my evidence adduced that I have been paying rents to the government for the last 50 years.
And what you have to say about this admission? The Tafazzal Haq Sarkar is the owner to the extent of half of the suit property, that is 0.27 decimal. The defendant number 1 and 2 possess the suit property by way of permissive possession granted by the husband of the plaintiff. If that is an admission in your evidence, then what?
But then same thing that,
Now tell me that after this admission, what more? First thing is, you admit,
my
you
admission,
admit the title may be undivided, not exclusive. Let us proceed in this. That will not prevent him from instituting a suit for recovery. Secondly, you also admit that you were inducted as a permissive occupant. If two things are there, then what more is required to be proved by the plaintiff? Order 12, Rule 6 will also come into play.
Admission.
Order 12, Rule 6.
but my admission, Milord, my
Sorry,
weakness,
admission, that's why Order 12, Rule 6.
my weakness, Milord, at the same time, my weakness does not. Milord,
Your
gives
only thing is you set up an adverse title.
Yes,
You could not prove adverse position.
I have shown Milord the rent. They have not been paying the rent to the government. I have been.
Is it one of the facet of creating a title or extinguishing the title?
No, Milord, but for the for the
I am
last.
asking you, the
Lordship.
payment of a government revenue,
Lordship.
is it a determinant factor for establishing a title or extinguishing the title?
No, Milord, but it is a determinant factor for establishing that I am in possession for the last 50
Who
years.
is not
For 50
saying
years.
under what category? If your position may be there for a long.
Milord, the possession
Now-
may have started as a permissive possession, but later, Milord, it has changed to adverse possession.
Correct. So mere long position in the property would automatically convert into an adverse position.
Have you claimed any
Again,
counter claim? There is no counter claim from your side.
Adverse position means.
Milord, we have taken.
Tell me whether a long position in the property would automatically be converted into adverse position.
Milord, with the knowledge of the
I am again asking you, sir.
no, simply long possession will not be the Milord, only factor. But Milord, the adverse possession, Milord, the plea of adverse possession which I
Who
have
is required to prove? Who is required to prove?
You have to adduce evidence.
Onus is on whom?
on me.
What discharge? When your permissive occupation become hostile, when, how, what,
Nick come, Nick we.
nec vi, nec clam, nec precario. There are three these golden principles of adverse position. What do you have done?
How you have proved.
Milord, I have proved that I have been paying the rents to the government. The owner is aware that
Their payment will not do.
the
Only thing
possession
is
has become
hostility.
adverse.
Question is hostility.
Hostility.
Hostility when? When you declare that your position is, that's a hostile.
They come to recover, but you raise hostility. You set up hostility.
What is the evidence? There is no evidence. You simply went by a long position. Recording in the LR, payment, that's all.
Not for 50 years. And they have
That's why
made,
I'm asking
they
you,
have
the
made
long
up a
position automatically converted into adverse position. So as one judgment, I am happy.
would allow me to come back tomorrow on this. Milord, just an
You will-
opportunity
you will-
Milord has already had
You will get at least 10 judgments
against me. Milord, if
and not a single judgment in your favor.
Milord, allow me to Milord
Nothing,
satisfy
not a
myself
single
on the
judgment
point.
in your favor. All the
Milord, one
judgments
day
are
time I'll
against
come back tomorrow. If there
Nothing.
is nothing, Milord may dismiss it
Uh,
tomorrow also, Milord.
We are dismissing it today, come tomorrow, we'll have our academic discussion. We'll have an academic discussion.
Milord,
Don't
be
worry.
kind enough to give me one opportunity
No,
to Milord satisfy myself on this point.
Because it's too settled a proposition, you can't. That's why I'm asking what are the points which you are taking? If these are the only points, unnecessarily delaying the disposal of the.
Milord, one day's time, Milord.
One day's time will not yield any good result. It will not yield. If you want, I can give you a time, but you go read Sridham Pasricha, read Kanta Goel against you.
Milord, I will.
Then, if you say the payment of rent, then I would say 1993, volume 3 is 1993, volume 6 SCC. That would go against you.
But I'll go through all this, whatever lordship.
Because the neither the entry in the record of right or a payment of rent creates any title into a person, nor is it extinguishes the title of a person. The inborn property fetching more than 100 rupees value can only be divested by virtue of a bilateral document, and that too in view of section 17 of the Registration Act must be done by a registrar. First principles. If you claim an adverse position, which is one of the 9th principle of that, then in that event, the onus is upon you to prove that when your position becomes adverse to the owner, the austerity, continuity, uninterruptedly, all these evidence has to be done. You are simply there and paying the rent does not mean that you have become, your position becomes adverse. So this is how the principles are. If all these principles are well set, unnecessarily you are taking a time and then coming back tomorrow and saying, I do not have any judgment from failure. Which I believe you will not get a single judge.
But I leave it to your lordships. If your lordships feel that granting time is for my satisfaction, if Millard grants, then all right, but leave it to your lordship.
What is your satisfaction? I just wanted to know, because
Since
you have
Millard
come
has-
to argue and you should be prepared with all
Millard,
the-
I am prepared on this. I have come with some judgments, but I am
what
not,
judgment.
Millard, I'll not rely
What
on those judgments today, Millard.
What judgment?
Millard, on power of attorney, on power of attorney.
I have already said that power attorney does not prevent. It was not a case of such nature.
So that was with respect to Millard's specific performance of contract.
I told you that. It was in relation to divestition of rights. It does not, it's no relation with the protection of it. Somebody intends to protect the property, then in that even no. No difference. If you want to divest them, what do you say is good? What more? What?
Can you improve your case? I don't know.
See what has fallen from your lordship, Millard, I would have gone through that.
That's
and-
my weakness, because I think that unless I clearly express my mind, what is playing in my mind, I think the bar would not be able to assist me.
Lordship.
Either correcting the notion, I may have a wrong notion in my mind. So that is what I feel is the fairness and the transparency in dispensation. If I keep mum nothing, then that's not the way. That's why I express so loudly. So that at least you should know that where we are heading. And correct us if we are wrong. Still our mind is open. Those line of judgments are against. Only on a proposition of law, Gurudwara Sahib judgment has now been upset, overruled by a subsequent decision of the Supreme Court. But this will not apply here because it says that it is a shield, not a sword. But we have taken as a shield, a defense. But it is you who have to prove it. You could not produce a single document. Even your evidence demolishes the case of adverse possession. What more you expect from us? Tell us. Tell us what to do.
If Millard allows me to come back tomorrow, Millard, I'll come back tomorrow, or if Millard wants to dispose.
The matter was initially moved by the counsel for the appellate. Next. What is this? Application? What is this application?
Lordship, an appeal against the order of the honorable single judge
My lord, I cannot,
Obviously.
my lord, I am for the petitioner.
in the income tax act.
My lord, I am,
The assessment, the reopening of the assessment?
yes, my lord, yes, my lord. My lord, the other side was supposed to file an affidavit in opposition, which they have not filed yet.
Why you want to go for a affidavit? What the single bench held?
Mother, the order is at page.
No, that's impugned order.
Actually, Mother, there is no finding by this single bench.
Nothing has been decided, sir. Why you are challenging it? It says that the matter is pending before the Supreme Court so far as the jurisdiction of the ITO concerned to issue a notice under section 148. Has it been decided by the Supreme Court as of
No,
now?
my lord, no, my lord.
So
I,
the matter was simply kept as pending.
my lord, I prayed for a stay because if they would
What
have
stay?
proceeded,
Then you go and renew a prayer before the single bench. Why you are coming up before the division bench?
my lord, I prayed
What
for,
is the demand? Total demand? What is the demand?
my lord, the assessment, it is still in the notice stage. The notice, I have challenged the notice and the proceedings. My
So
lord,
they
the
must have indicated that how much escaped from the assessment.
My lord, the demand is not raised till the assessment is completed. I have
This demand
challenged
is?
not, the demand is not raised till the assessment is completed. I have challenged
So,
the notice of initiation of 148. That
on
is
the
the-
ground of jurisdiction only.
Yes, my lord, the
And
jurisdiction.
then nothing. Then you go and pray for a stay before the single bench. What is the use of keeping this here?
My lord, already our division bench in the coordinate high, presided over the Chief Justice has given a stay. Division bench of Bombay High Court has already quashed the order.
That order has been challenged before the honorable.
My lord, there are
Sir,
subsequent orders also where the notice proceedings was
No,
quashed.
the judgment of our Chief Justice now is a subject matter of challenge before the Supreme Court.
No, my lord.
all matters, whatever cases, at least.
The division bench of Bombay High Court is
A
challenged.
lot of cases have been tracked and they are pending with honorable export, my lord. More than
And what the apex court has said,
My lord, they have just
pending that
accepted,
adjudication.
nothing.
they have accepted the petition, my lord. As far
No,
as,
that is true. That is true.
my lord, our division bench judgment is not challenged before the Supreme Court. Our division bench has already only given a stay.
And the challenge against XYR has also been tagged with the same bunch.
No, it is a special petition which is directed. Means till date, it has not been leave is not granted.
Well, continuation of delay has been allowed and the SLP has been admitted. And
Not
tagged with-
admitted.
tagged with
Not
the early-
admitted. No.
No, my lord.
Release these cases along with SLP's diary number such and such,
Yes, my lord.
and they connected. That means the
That
leave
means
has not
that-
been granted.
That is the Hexaware technology that has been challenged.
Others have been admitted. Leave has been granted.
Yes, my lord.
My lord, as far as I know, the
Issue
only
notice.
Diary number 8.
The bunch of SLPs, these petitions were tagged with the Hexaware SLP where notice has been issued.
Where is the judgment of our chief,
My lord, I have attached, last day I have submitted is Giridhar Gopal Dalmia.
where is the judgment?
My lord, as far as I remember, I have submitted on the last day. It's there on the file. It's mat number 169025.
Oh.
Mat number
No, this is the
1690.
1998 matter. I'm talking about the Honorable Justice, Chief Justice Shivagnanam. Where is the judge? Where is the
My lord, I
order?
have submitted on the last day because the first order was
Hey,
based
I'm
on.
not unable to.
What is your junior?
All Bombay, Calcutta, yes. Just 1 minute. No, it is the Raja Basu Chaudhary's judge order, Calcutta. Where is the Girdhar Gopal Dalmia's judgment?
My lord, I have submitted because the
It is
last.
not here. Justice Raja Basu Chaudhary has referred this judgment.
My lord, I have the mat number. My lord, as far as I remember,
I
because.
know it is given, mat number 1690 of 2023.
Yes, my lord.
Where is that order?
My lord, give me a short passover. I send.
Taking the privacy case and order passed by the Honorable Division Bench of this and Gopal Dalmia, such and such. I am of the view and include notice. Where is this order? Where is the order?
Lordship, there is another.
That's the whole problem with the virtual hearing. They do not give any copy. They refer some judgment, but they do not. They cannot produce.
My lord, give me a short passover. I'll send it to my junior. My lord, I have.
Why you are not ready, sir? Why don't you send it beforehand?
My lord,
Somebody
last.
who is representing you here physically, why not he's carrying a copy? Simply he appeared and says that somebody is appearing virtually, hear him. Without any copy of the judgment and order, and you are referring that judgment and order. We are not finding it from our record. Many judgments from the Bombay, we are getting it. Of a single bench, we are getting it. Single bench has relied upon a division bench judgment. We wanted that division bench judgment. You are not able to give us.
I just give me, my lord, 5 minutes. I'll send it to the junior. I can mail in the email of the Honorable High Court.
We will stop virtual hearing in this way. If you do not assist the court, then really we are at loss. Then what to do? Every time the matter is adjourned for this lapses. It is expected that you will send all the copy. If you have the another advocate who is physically present in the court, then he must carry those copies. Whenever you refer, he will just give it to us. What to do? There is a judgment of our High Court because I find from the order of Justice Basu Chaudhary,
My lord.
reference of that division bench. Can you find out the order?
My lord, we can find- I will find it, my lord, and there is another-
দেখো তো, ডেটটা দেওয়া আছে।
My lord, it refers to Girdhar Gopal Dalmia.
That is what is MAT. We wanted that order of the Chief Justice, the division bench.
And on the other side, I had also given a copy on the first day when Justice Madhuresh Prasad was taking up the case. I had given a copy to the other side and also the bench. Somehow it was displayed.
Lordship, there is another judgment of a division bench of this court on the same issue where the prayer was turned down by the division bench. That is was division bench presided over by just Honorable Justice Devanshu Vasak.
Where is that judgment?
Barkor,
We are coming at 2 now. We are already this. We are coming.
I'll
at 2.
provide the print. My lord keeps this judgment.
This is what we are keeping. We got the Gopal Kumar Dalmia. এটাই আছে। না ওটা হয়ে গেছে।
দুটো বার করে রাখেন।
বার করে নেবেন আপনারা।
ঠিক আছে।
দিয়ে দিচ্ছি।
বলছি এর আগের অর্ডারটা আরে কে জানে ফাইল থেকে অর্ডার পেতে চলে গেল আগে কি মানুষের কোথা থেকে যাবে আমি খেলাম যে তুমি জুনিয়র দাঁড় করি তো সাইকেল পেপার পাঠাবো এবার দেবাংশু বসাকে জাজমেন্ট দেবে দিয়ে বলবে স্টে দিতে হবে না আমি বলতে সালে এপিডেভিটের জন্য যদি এত হ্যাপা করতে থাকি তুই কি যাবি কোথাও সময় ঢুকছি তুই প্লিজ ঢোক আমি তোকে হোয়াটসঅ্যাপ করছি অর্ডারটা প্রিন্ট আউট কর কেদার গোপাল ডাকিয়া আর আমার যে মাধুরেশ প্রসাদ ছিল তো প্রথমবার যখন সেটা দিল না আমি আজ কেদার গোপাল ডাকিয়া জমা পড়েছে সেটা তো আগেরবার রেফার করেছে ওটাই তো না বোম্বে হাইকোর্ট ছিল এখান থেকে আমার আরে হ্যাঁ আরে বলো না পাগল করে দিচ্ছে রাজীব পাল বলছে আমি কেন স্টে দেবো আমার তো এই আছে এই আছে এবার অর্ডার সব কটা দেওয়া আছে বলছে আমি ভার্চুয়াল কেন করছি আরে ও আদার সাইড না এই পুরো মামলাটা এখনই শোনাবে বসে বসে দেখছি আমি পাঠাচ্ছি রাখো রাখো বাবু দাঁড়াচ্ছেন বলো বাবুদা হ্যাঁ বলো 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 আরে পাঠিয়ে দিয়েছি আরে আগের বার 3 বার দেওয়া আছে অর্ডারটা আদার সাইড কে দুবার ওইখানে বেঞ্চে দুবার বলছে নেই ফাইলে পাঠাচ্ছি পাঠাচ্ছি না সে পেয়ে গেছে বাট সেটা আমি আবার তাও দিচ্ছি দাঁড়াও রাখো আমি রাখো কয়েকটা অর্ডার পাঠাই একটা মেল করেছো অ্যাকসেপ্ট করবে তাড়াতাড়ি হয়ে যায় মেল করে ওকে ওটা এখানেই আছে আহ কি নাম তোকে মেল করে হোয়াটসঅ্যাপ করেছি না 5টা বাবুদাকেও করা আছে ও স্টে আটকাবে, আমি যেটা ভেবেছি আমি বলবো যে মাই লর্ড আই এম প্রেসিং ফর কোয়াশিং অফ দ্য অর্ডার বিকজ ইটস ইলিগাল। লাস্ট স্ট্যান্ডিং অর্ডার তো ওটাই। তাই জন্য কেস লগুলো পাঠিয়েছি। দেখছি ও হি ওয়ান্টস টু ফাইট আইডেন্টিফাই ডিএসসি লড়াই করতে চাইছে। লেট হিম ফাইট। আর আগে যে অর্ডারটা রেফার করছে সেটা তো আমাকে দিতে হবে পড়ার জন্য। আশ্চর্য লোক তো ডিএসসি তো মহাতে তো এফিডেভিট না দিয়ে মামলা করতে চাইছে। ঠিক আছে, তুই বাবুদাকে ফোন, ও এফিডেভিট করবে না, ও স্টেটাকে তোলার চেষ্টা চালিয়ে যাচ্ছে। ও স্টে তোলার চেষ্টা চালাচ্ছে, আমি ঠিক আছে দেখছি। আর আমি বুঝতে পারিনি যে আমার কেস করা উচিত ছিল। ঠিক স্টে তো ছিল ভাই, এক্সটেনশন অফ স্টে হবে। প্রত্যেক কটা বেঞ্চে তুলে দিলে মামলা, প্রত্যেক কটা বেঞ্চে তুলে দিলে মামলা। ঠিক আছে, জয়মালে ভাবছি, জয়মালে ভাবছি কথা বলতে আরম্ভ করেছিল, বলেছিল এফিডেভিট দাও। মাধুরেশ 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 প্রসাদের ভাই দেখছি। হুম। মানুষ ভাই বেরিয়ে যাচ্ছে। हुआ? আরে কি ঝামেলা ডিএসসি টা করছে, ও এফিডেভিট দেবে না, ওর পুরো মামলা শোনাবে হিয়ারিং কোর্টে এসে। এবার আমাকে বলছে বাইরে ঢুকিয়ে দাও। স্যার পড়া তো কত এক্সটেনশন অফ হিয়ারিং কোর্ট আছে, তো স্যার হিয়ারিং কোর্ট আমি এখান থেকে বসে আমি কি করবো? ঠিক আছে ভাই, মামলা করলে আমি মামলা করবো, ওর ও স্টে আটকাবে। ও আমার একটা কোন মানে এখানে দেওয়াংশ কথা ঠিক আছে, এখানে ওকে স্টেটা দেয়নি, বলেছে যে কনকারেন্ট জুরিসডিকশন আছে। তো সেটা নাকি দেবে, সেটার কপি আমার কাছে কবে আসবে পাবে কিনা, পেন্ডিং কার কাছে পাবো। না না, এটা প্রবলেম হলো আমি এক্সপেক্ট করতে আমি পৌঁছে যেতাম, পৌঁছে দেয় না এটা না গেলে। ওর কাছে আছে একটা অর্ডার, ফাইল থেকে কোনোভাবে মিস হয়ে গেছে আমাদের চিফ জাস্টিসের অর্ডার, ওর কাছে দুখানা করে সেট দেওয়া আছে, ও একটা বার করে লাস্টে দিল মাই নট আই হ্যাভ, খুঁজে পাচ্ছে না ফাইল, আবার পাঠাচ্ছে, আবার দিতে হবে, আবার বলো মানে ডিভিশন বেঞ্চ না, কলকাতা হলো তো স্টেট সিঙ্গেল বেঞ্চ স্টে দিয়ে দিয়েছে আমাকে, গুচ্ছের অর্ডার আছে সিঙ্গেল বেঞ্চের স্টে, স্টে দিয়ে চুপচাপ বসে আছে, কিচ্ছু করছে না, ডিভিশন বেঞ্চ তো স্টে দিয়ে ছেড়ে দিয়েছে। এই একমাত্র ডিএসজি যেটা নিয়ে লড়ে যাচ্ছে, বলছে এফিডেভিট কেন, আমি এফিডেভিট আরে কি ভাই এফিডেভিট দে, দ্যাটস হোয়াট দ্যাট ওয়াজ দ্য লাস্ট অর্ডার। Let's see. আরে কি আশ্চর্য ডিএসজি এফিডেভিট দেবে না আমি এবার জাজ করবো মনে হয় as per the last order they are supposed to submit an affidavit let them come up with an affidavit I will go and appear in person বলবো এবার আরে no if they want to argue the matter let them submit an affidavit or give me a time I'll teach কিন্তু কালকে আমার রাত্রিবেলা প্রিন্ট হয়ে যাও ক্লায়েন্টকে তো পয়সা পাচ্ছি না খরচা বেশি হবে ওটা বেশি হয়, মাথা খারাপ হয়ে যাচ্ছে এইগুলো কোনো মানে হয় না। intentional harass করা এ পাবে না স্টেই দেবে সেই সারা মামলা শুনিয়ে ছাড়বে আবার হিয়ারিং এর মধ্যে যে একবার হিয়ারিং হয়েছে স্টে দিয়েছে পরে জয়মালা বাগচি বেশ ভাই দাও স্টে এই আবার হারিশ টান্ডন আরম্ভ করেছে শুনতে ভাই শুনবে শুনবে ঠিক আছে আমাকে আবার ল বোঝাতে হবে বোঝাবো না কোনো হিয়ারিং চলবে আমার 3টে 3:30 অব্দি আমি টেস্ট করবো না একটু করার চেষ্টা করছো হিয়ারিংটা এখানে করবে এফিডেভিট না দিয়ে নাহলে স্টে দেবো না ও মামলা করবে আর মামলা করবে উইদাউট এনি এফিডেভিট কি মহাবিপদ দাঁড়াও বিলিভ করি জানো তো আমার
Sir, my lord, I am giving your lordship another coordinate judgment. Where the matter was finally disposed of by the learned, his lordship of the single bench.
My
The
lord,
petitioner-
my video is not on my lord, somehow.
Video
cannot
is
switch
not
on.
on.
That's your problem, sir.
No, no, my lord, it's okay. My lord, the other side had stopped. My lord, the system.
That side it's stopped.
এখানে তো নয়।
No, my lord, it's okay. It's working now.
Lordship finds two match appeal, 78 and 79, same point, decided by a coordinate bench. And notice this too.
Yes.
My lord, may I have a copy of this
The
order?
same, here also the subsequent notification was given.
Yes, the same, the subsequent division bench has taken, but the difficulty is that this subsequent division bench did not notice the earlier judgment.
Of the, my lord,
Oh. No, earlier judgment of our High Court.
my lord, that was the interim order.
True.
That was not, the appeal was not disposed of. Here the honorable division bench heard the appeal and disposed it of.
But the Bombay High Court has finally disposed of that.
Exaware.
And that
My
That
lord,
is matter of
my lord, here I want to
was there
mention.
any stay of the operation of the order or something?
No,
No, my lord.
If that
My lord,
is-
subsequently, there are a lot of judgments by Bombay High Court where even the notices under 148A was squashed. My lord,
What can be done?
my lord, only the, and what the impugned order is here.
No,
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 impugned order is a,
Single
kindly
bench,
visualize, impugned order is the issuance of notice under section 148.
lordship. Nothing has been decided, my lord, correct.
Now the question is, there are two aspects. I tell you, I am conscious that at the note sheet show cause stage, the interference of the court is very minimal. Because the authority have not decided as yet. But there are settled parameters on which the show cause notice can be interfered with. One of the principle is, if the notice is issued by an authority who has no jurisdiction to
Gotcha.
issue that. If that is the question,
Right, my
then
lord.
in that event, the court will definitely go into that
Right, my lord.
aspect.
But my lord, my learned friend for the petition appellant has failed to show your lordship still now that in Hexaware or where the bench of the Honorable the Chief Justice had issued interim stay, the subsequent notice under faceless scheme was not issued.
My
Here
lord,
the notice was issued.
This
Their
was under the
grievance was-
scheme,
it
that
should be
was
baseless.
under the scheme, I think section 151,
A.
capital A.
yes, my lord.
So that notice was issued in all the cases that we are dealing with, not in Hexaware, not in the
And Hexaware was the ordinary notice under section 148.
lordship.
No, my lord, it's the
No
same.
51A was there. It was not considered by the Bombay High Court. not
My
by
lord,
the Honorable Chief Justice in
my lord, the
that,
other side is somehow
Sir Gopal Dalmia.
misinterpreting the statute, my lord. May I
Please,
please,
please.
Yes,
may I,
Exhibit does not deal with this, my lord.
my lord, the
Exhibit
Hexaware
statement
judgment
says
completely
jurisdiction
deals with
assessing
section
officer is not
151.
authorized to issue a notice under 148A in view of SST.
That is
There,
my
it
case,
was
my
not
lord.
that subsequently the authority had issued a notice.
further scheme was given and notice
A notice
conferring
was
a
given.
power. Conferring a power.
No,
Yes,
my lord, there is no such,
Page
no such
77, my lord, of the
notice.
state.
Let us.
No such notice, my lord.
Let us see. Page 77.
Yes, my lord.
And this was, the date is
Date is lordship
2018.
17/10/2024.
17.
10.
My lord, 17/10/2024, there was
Where
a
is that?
142
Where, yes, yeah, I got it, yes.
And the original notice is 15/3/2024. And my lord, the main crux of the dispute
No,
arose.
no, this is the finance department who issued a notice.
Both notices.
I'm talking about the scheme.
Oh, scheme, my lord. Scheme is 158A. Wait a boy,
151, my lord, 151A. My lord, may I place a judgment of Bombay High Court of Aristo Pharmaceuticals where it
That
says
is
that
also under challenge.
that is not under challenge, my lord. My lord, as far as I know, that Aristo Pharmaceutical has not gone to be challenged. Only Hexaware has gone, my lord. After that, there are hundreds of judgment of Bombay High Court, Delhi High Court, and Madras High Court.
Sir, I believe that this is such a case which raises a very important issues. For that, I think your presence before us is very much necessary.
Yes, my lord.
It cannot be done. We are fixing this matter. Tomorrow you come and argue the
My
matter.
lord, I stay in Kolkata, my lord.
Yes?
Right now, I'm in Kolkata, my lord.
No, that's I know. That's why we are facing a lot of difficulties because everybody is referring several judgments. Nobody is carrying those judgments.
My lord, my junior has all the judgments I'm referring to. Aristo Pharmaceuticals is already there.
My lord, we
Just
need the scheme.
I just wanted to look at what is the date of the scheme.
My lord, the scheme came into effect from
March
29
2023.
March
So
2022.
that was before the division bench presided over by Justice Chief Justice. So in that event, it was taken into consideration.
My lord, we don't have the pleadings before the Honorable Chief Justice, so we do not know.
Whatever.
Now, my lord, what happened is after this, the only grievance that the petitioner says tries to bring to the notice of the court is, my lord, kindly takes page 33. Lordship has it.
This judgment of Aristo Pharmaceutical was in relation to an international taxation charges.
My lord, the issue is 148. Whether the
No, it is
148
not 148 because it talks about paragraph 18 that once it is outside the purview and the comes under the exemption, then in that event it will not apply. That's what it says. The faceless manner.
My lord, 2024 161 taxman.
Please come to paragraph 8 of that judgment where the quotation is done so far as Abhin Anil Kumar Shah's judgment is concerned.
Yes, my lord.
Because it says the central charges and the international taxation charges. There are two aspects. And it says that it comes within the purview of central charges, then they apply that case.
Yes, my lord. For two charges, international taxation and central charges can be issued by JO. Other than these two exceptional cases, everything has to be faceless. For central
No,
charges,
no.
which is,
It says that pertains to essential charges, it will be required to be excluded, cannot be accepted, and it will be required to be rejected.
yes, my lord, it has to be the exclusion for jurisdictional officer to issue a notice is under the two circumstances, whether it's
I believe,
international.
raise this point before the officer and let him decide. Let him decide. No cause.
My lord, the issue is the jurisdictional officer is out of jurisdiction of issuing this notice.
No, you take that plea, let him decide, then you take that plea. We will keep
But-
this open. We'll keep this open.
My lord, how come the
We'll keep
person
this
who is
open.
out of
No.
jurisdiction decide whether he's in jurisdiction, my lord?
Why? Like an Arbitration and Conciliation Act, the arbitrator can decide its own jurisdiction. There is
Well,
no
this is-
fetter. If you raise a plea of jurisdiction, definitely that's the show cause stage. At this stage, why the court will interfere?
My lord, they have passed an order under section 148 AD. My lord,
Where is the then order is how you are challenging an order in the writ?
my lord, it is
You have
not appealable.
you have a avenue of appeal before that.
My lord, that order is not appealable, my lord.
Which one?
148 AD, my lord, page number.
Show us the provision. Show us the
My
provision.
lord, page number 30 in the math. Page
30.
number 30 is the order. Even this order is out of jurisdiction. My lord, I'll show you the provision, my lord.
Have you challenged this in the writ petition?
Yes, ma'am. This order and the notice, both. My lord, section 151A says that this too has to be compulsorily issued by faceless. They had a provision of transferring from jurisdictional officer to faceless officer. Instead of transferring that file to faceless officer, they continued with the jurisdictional officer. 56.
No, you were submitted and they say that since you did not furnish any response to the notice and they proceeded that there is nothing that you can deny.
My lord, that is on the merit of that matter. My lord, I'm not challenging
What are
the
you
merit.
talking about? And then it says that it is a fit case for a notice under section 148 of the IT.
My lord, this order cannot be passed by jurisdictional officer. That is my
What can be, what can? Then I think let it be decided. Why you did not file your affidavit?
But because we were under
And he has
the-
given opportunity to furnish his
we,
response.
yes, my lord, we will
My lord,
file
they
it. Give us a.
Why you did not file it on 24/1?
My lord, they are not filing it and they are
My lord,
doing the hearing every time.
Since it was
I'm not-
pending with the Supreme Court, the matter will not.
So what? But
My
the
lord, we'll file
affidavit
it.
should have been filed taking that plea.
My lord, will file it.
I do not want to express my view at this stage. Anyhow, we are extending the time to file their opposition.
My lord, stay may be expensive.
Pursuant to the order dated 24/1/2025. Let's call the next.
91.
91.
Learned AG is appearing online.
Lordship,
But I appeal for the
91.
respondent in this matter.
Lordship, in this matter, I'm being led by Mr. Moinak Bose, Your Lordship. He's engaged before Honorable Justice Kapil. He has asked me to pray for a very short Passover.
Why?
Lordship, he was there in the first of Lordship. He has just requested me to pray for a very short Passover, Your Lordship. On the last occasion, Your Lordship, the learned AG had been opposing on the point of maintainability, Your Lordship.
What, that is what is there because
Lordship.
they are arguing before the principal seat.
Lordship. So on that point, Your Lordship, I am being led by Mr. Moinak Bose, Your Lordship. He will be arguing the matter, Your Lordship. Kindly grants a
Then
short.
you argue before the other circuit bench.
Lordship, kindly makes it not today then.
Not today, Karo. Call the next.
Grateful, my lord, grateful.
I'm grateful.
Moinak तो कुछ चले गए.
92.
Lordship for item number 92.
Yes.
Lordship, the respondent have filed their opposition. I am praying for 1 week accommodation to file the reply.
That was given to you.
Yes.
That was given to you on 10/2. When they have filed, have you received?
Yes, we have received and we are paying for 1 week accommodation to file the reply.
It is submitted by the appellant that the appellant in opposition as well as.
So she's
Yes,
running.
call the next.
Item number 93, the opposition hasn't filed any.
Both are identical.
On item number 93.
Next
they
one,
haven't
I'm
filed.
not,
They haven't.
next time I'm not there, same order. I'm written,
So you do not want to file opposition.
same time, I'm not there. The order was passed. The order was.
Where is Mr. Sayan De? And Miss Isha Acharya?
It was the 93. No, 93, opposition contradiction. Item number 93.
But they are supposed to file, not you.
Yes, in 92, I am praying for
Yes.
something. Just a moment.
93 what? Would you file or you will not file?
I'm not happy.
Then where are they? Sayantan De and Miss Isha Acharya. Miss Isha Acharya is practicing here. Where is she?
How we to leave by righteous matters common. We just leave by.
Not today. Welcome. Yes, next.
94.
Milord, I'm extremely sorry, Milord. I could not cure the defect due to my ill health, Milord. Kindly accommodate for 2 days, after 2 days.
The fact is that section 5 is to be filed. Why you
Milord,
not filing
I
it?
could not do so. I was sick, Milord.
The counsel for the appellant submit that he may be the matter may be adjourned to cure the defects pointed out by the additional staff report. Let this matter be listed in the next circuit way. In the
Right.
meantime, the defects as pointed out by the staff reporter be cured.
Grateful, my lord.
Yes.
My lord, I am for the petitioner, my lord. In item number 95, I am praying for 1 week more accommodation for service. The service has not affected, my lord.
Why you did not affect? There was a direction.
Yes, my lord, but I'm
On
praying for
10-2 says it was not complete. And still you are saying that it is not complete.
Yes, my lord, I'm praying for apology, my lord. Kindly give
Sorry.
one more week time accommodation.
No, no, sir. On the prayer of the appellant, next circuit bench. Next.
Okay.
This is the point.
My lord, I am appearing for the petitioner respondent.
Yes.
My lord, the appeal is filed.
Who is appearing for the writ petitioner respondent?
I am appearing for the petitioner
And who is for the
respondent.
appellant? State, Mr. Vikas Singh. Anybody knows him? Where is Mr. Vikas Singh? He sits here in the circuit bench. Yes, where is he? There is no representation on behalf of the appellant when the matter is taken up today. Why the defects are not removed? 104 days delay.
Yes.
Where is the section 5?
না না ওইটা শেষ দিলে অ্যাপ্লিকেশন করতে হবে My lord.
Yes.
While dismissing the earlier appeal by the parents of this appellant lordship, the order was partially allowing us wherein a liberty was granted to this appellant lordship to file the, he is the actual aggrieved person.
I understand.
Yes,
Liberty does not mean that the limitation would be dispensed with. When
My
there
lord.
is a limitation, will you not come up with the application seeking condonation? Maybe a good ground for condonation, but at least the application must be there.
Lordship, we apologize, pray for a leave to file an application for under section 5 of the Litigation Act.
Seen the report of the additional report, staff reporter indicating that the instant appeal is
Milord, in this matter, Milord, I beg to appear on behalf of the petitioner appellant before your lordship. So this appeal Milord, arose out of an challenging
what is the
the
defects, delay, section 5. Where is the section 5?
section 5 is there, Milord, your lordship. I have already sub copy upon the all respondents. You are under advocate on
It is can
record,
two
Milord.
or what?
My lord,
Which one? Can 1 or can 2? Which one is a section 5, madam?
my lord.
Which one is section 5?
Section 5, Milord, your lordship will find from
What do you say, sir?
delay of 129 days is there, Milord, in filing the appeal before your lordship.
We have to file opposition.
Section 5. What? Tell us.
As your lordship.
Paragraph 3 to Milord, onwards, Milord, your lordship, I have explained it totally.
Madam, who was the earlier advocate and record?
Earlier, advocate on record, Milord, it appears from the copy of the order.
Before the single bench.
My lord. I have annexed
I am appealing on behalf of the West Bengal College Commission, my lord.
Page 98 of my application for Milord, say, Milord, earlier, Ekamul Bari Imtiaz Uddin, MS Rinka Chakraborty.
Yes.
3 names are there, Milord.
Madam, you have made certain aspersion against the then advocate and record.
That's why I find from this, Milord.
You said that
Rinka Chakraborty was advocate on record. As I find from the writ petition, page 28, your lordship.
Madam, you made certain aspersion against her.
Yes, my lord, that is, that
Then
is the fact, my lord, that.
she is entitled to a notice, madam, before we proceed. No,
No, I did not.
she is entitled to a notice.
My lord, actually, my lord, as I am told, my lord, I am not there. I am told by my client, my lord, that he was informed that the writ petition has been allowed.
Correct. So if there was a wrong information given to him by the advocate on record, that the order has been passed favorably, and
My
it
lord.
appears that it is not passed, that means there is a misconduct on the part of the learned advocate in making a wrong communication. Then before we proceed to accept that, she is entitled to be heard. Otherwise, this aspersion will go without any opportunity of hearing. That cannot go. She is entitled. Whether she communicated, not communicated, she has to come and say.
Clerk of the learned advocate, my lord, from the office of the.
No, how the clerk knows the order goes favorable? Is the advocate in record? You have stated in your petition that the advocate in record communicated.
Office of the advocate on record, my lord. I did not say that. The learned advocate, your lordship, I am coming to that. Your lordship, kindly have a look. I am placing that.
Please.
Your lordship, kindly come to page 5, my lord, paragraph 3, middle portion, my lord. After the solemn order was passed, your applicant was informed from the office of the learned advocate on record that the writ petition was allowed in his favor, for which your applicant did not knock the clerk to obtain the same hurriedly, my lord. This is the averment, my lord, not the learned advocate personally. From the office of the learned clerk, my lord, dealt with that, my lord. Certified copy also was obtained by him. No direct aspersion, my lord, against the learned advocate, my lord, office of the learned advocate. And the concerned clerk was, my lord, dealing with that.
The letter come that if for the act of the agent, the principal is responsible. So let her come and say that who communicated this.
Concerned clerk, my lord, I shall have to take the name of that concerned clerk from my client, my lord. Your lordship kindly takes it up, my lord.
No, Miss Rinka Chakravarti, who informed. Rinka Chakravarti is practicing here or somewhere else?
That I do not know, my lord.
Yes, then is she present in the court?
My lord, I do not know my lord, where she is practicing, my lord, I do not know. I am told by me.
Ask anybody if she can be informed. She must know.
As per instruction of the client, my lord, I have said so, my lord. But I was
Madam,
told by the
you know that if there is any aspersion,
my lord, I know.
This fact constitute a misconduct on the part of a legal professional. So before
now
we accept this, is she or he not entitled to be heard? Because we are accepting that it is true. She is entitled to be heard.
Clerk, concerned clerk.
We do not know. When you talk about the office, you did not say clerk. Office. Let her come.
Clerk was engaged for obtaining certified copy. That was my submission before your lordship.
No, nothing.
Concerned clerk did not inform that.
Sorry, that's my very firm view. When any aspersion is made against the lawyer, then that lawyer is entitled to be heard.
I did not direct, no aspersion.
No, direct or indirect,
aspersion.
the indication is, have you contacted her?
Concerned clerk maybe will.
Whatever, let her come.
I shall ask my client to bring the learned, the clerk of the concerned learned advocate. I can say so. I can say so.
No, sorry. The advocate is still there. She has a clerk. She will tell what is the truth.
Need to take more time, Miller.
Sorry.
There is some urgency is there, Miller.
No, I will see. I will see.
If you also so please, Miller, certainly I shall have to serve notice, Miller. But your lordship kindly have a look to the order, my lord. Handicapped person, my lord, participated in the selection process. He was impaneled, my lord. Later on, he was not issued any appointment letter in the post of assistant professor in English, my lord. And one post is lying vacant. This is my, my lord, submission before your lordship.
Everything has been recorded.
The Honorable Singh is that relied upon a government order, my lord. I am also relying that, my lord. Later part of the said notification is applicable to me. This is my humble submission before your lordship.
He's coming.
But into Notarana Appellate page 98, your lordship, kindly have a look to that.
Madam, you are diverting the core issue. Unless we condone the delay, we cannot enter
That's
into.
true, that's true, my lord, certainly, my
So
lord.
let her come. Let us see that she must know that what the amendments have been made regarding her office. So let us see. You
Lord,
talk about office.
This will
Let
take
us
much
see
more time,
that,
your lordship. I shall submit, sub copy. But your lordship kindly will decide it.
No, she is here. We'll decide.
This will not become influx as your lordship kindly takes it. I shall try by today, my lord.
No.
I shall try to contact that advocate, my lord, subject to your lordship kind consideration over telephone, and I shall request her to appear.
No, we have already informed her she's coming. Don't worry.
Oh, very well. The petition was not dismissed, it was disposed of with certain direction.
She is in the district court. Tell her that this court wants her to be here.
Password for 10 minutes.
There is a panel which is prepared. The appellant claims that he is in serial number 2.
What is the next year?
Where is the annexure of panel?
My lord,
40, 72,
70.
60.
Lord, the panel was not act. Interview was held on the panel subject. Page 76. Yes, not page 76, your lordship. $25 one category PWD within bracket B.
What happened to Tinku Das? Has he joined?
Yeah, I joined.
Then what is your grievance?
Grievance is another PWD A category post is lying vacant. Nobody, but in spite of issuing appointment letter
What
in
is
favor
this?
of them, they did not join.
PWD-A means what?
Person with disability, my lord.
And what about PWD-B?
B, my lord, your appellant is PWD, my lord, and post of PWD, my lord, B, A is live vacant. A is live vacant.
I am asking you, what is this PWD-A and what is the PWD-B? When there are two categories, there must be a
Category, you have two
distinction.
categories there, but that was not.
Why? Why? I just wanted to know, what is this?
My lord, I am telling you, Lordship, my lord, while the advertisement was published, my lord, there was no category A, B, C, or nothing was there. Now, while the panel was published, my lord, this is that I have shown to your lordship, there is PWA and B. So, my lord, I am submitting it with your lordship. Might be there is.
So what is the rationale between these two, PWD-A and PWD-B and PWD-C? What is that?
My lord, kindly come to page 156 of the, my lord, the CAN application.
Yes.
My lord, kindly see the as per, my lord, the government memorandum of, my lord, 8 July 2019.
Yes.
The vacancy, my lord, lordship has got it, my lord, page 156.
Yes. Yes.
My lord, kindly see the A. 12 vacancy unreserved person with disability, blindness and low vision.
Okay.
B is 32 vacancy scheduled caste person with disability, locomotor disability including cerebral palsy. Well, the petitioner is belonging B category. Kindly see, my lord, petitioner's application, my lord.
This PWD-A and PWD-B, capital B, these are all small b. I just wanted to know that why it is done. Where is a source of these two different categories?
My lord, this is, my lord, kindly see the 100-point roster.
I understand, sir, 100-point roster.
My lord.
I understand.
My lord.
Then in that event, why you are making those category wise, the panel at page 75. In PWD-A, you have included 1, 2, 3, 4, 5, 6 person. In
My lord, as per
PWD,
vacancy, my lord, as per vacancy requisition received by West Bengal College Service Commission, my lord, we have PPR.
show us that you have shown that these are the vacancies which are only restricted to blindness and low vision. These are the vacancies only a locomotive disability, and these are the reasons which are only for the those speech impairment or those cannot hear.
My lord, may I submit, my lord?
And then why not the D? D should
My
also
lord.
be there.
Yes, my lord. If there is a, my lord, D, if we have received any requisition in respect of
Show us that
PWD,
in the advertisement you have shown that.
my lord, we have not advertised, my lord, when we have advertised, we have not, my lord, received requisition. My lord, after our, my lord, regulation says, we shall publish the vacancy list prior to, my lord, publication of, my lord, merit panel. From the advertisement to, my lord, preparation of, my lord, the merit panel, we can receive the requisition from the respective college of the vacancy. That's why, my lord, our regulation of 2018, my lord, regulation 5 is specifically says the West Bengal College Service Commission will publish the vacancy list prior to publication of the merit panel. Accordingly, we have, my lord, published the vacancy list. Thereafter, we have published the merit panel. As per, my lord, the last cut-off date.
Oh, vacancy list in a particular category that has to be published.
Yes, yes, my lord.
Where is that publication? I just wanted to know.
My lord, kindly see the vacancy list.
57 by
Which page?
Yes, my lord, I'm giving, my lord. I'm giving, my lord. My lord, page.
$58, $53.
No, my lord. 111, it has been vacancy list. Tentative vacancy list, my lord. Lordship has got it, my lord. The subject English, page 111, my lord.
These are the vacancy lists.
Yes,
I
my lord.
wanted to know where is a
Yes, my lord.
advertisement
I'm
indicates anything.
Yes, my lord. The next page, my lord. Next page, my lord. Page 112, PWD A, PWD B, PWD C category, this is in respect of English. My lord, page 112. This is vacancy, the category. My lord, Mexiganj College, PWDA, Netaji Subhas Mahavidyalaya, PWDA, Chitta Mahato Memorial College, PWDA category. Then, my lord, Raniganj Surendranath Mahavidyalaya, PWD B category, only one vacancy. Then, my lord, Mohisadol Girls College, PWD C category. We did not receive, my lord, PWD. Whatever, my lord, requisition made by the respective college as per, my lord, maintaining the 100-point roster and after authenticated by the BCW department, we have, my lord, after accumulated all the vacancy, my lord, we have, my lord, published the vacancy list as per category. My lord, kindly see the page 11, 111 to 12, subject English. All category wise, we have published the vacancy. Now, the petitioner is the PWD B category. The petitioners, my lord, the prayer, there is a, my lord, the vacancy which is not been filled up due to, my lord, the my lord, available, my lord, the candidates from PWD A category. So, my lord, the petitioners,
What is his
the
impairment?
recommendation should,
It's a
my lord,
locomotive, it's a locomotive impairment, or it is all blindness or low vision?
no, my lord, the petitioner is belonging to, my lord, the B category, that is locomotor disability. So, my lord, the petitioner's application and, my lord, he filled up his, my lord, the applicant at the time of interview, he, my lord, himself, my lord, declared that he is a locomotive disability under locomotive and, my lord, he belongs to PWD B category.
Number of post vacancies that has not been mentioned in the page number 111.
Yes, my lord.
Where?
The college, that means, my lord, the one vacancy, which college, that vacancy, college name has been indicated.
Yes, madam, this is a matter where you
This
were
is the-
conducting the case. This is relating to Sikhor Sarkar before the single bench. Your name appears before the single bench.
My lord, your lordship kindly have a reply is below paragraph 4. Paragraph 4 of page 92.
Madam, have a patience. She
My
has come.
lord,
Yes.
sorry, beloved, beg pardon.
You appeared along with Mr. Ikramul Bari and Mr. Imtiazuddin. What? Madam, kindly don't get panicked. Don't get panicked. It appears that this matter, before the single bench, you appeared for the petitioner along with Mr. Ikramul Bari and Mr. Imtiazuddin. The writ petition was disposed of. Now, the writ petitioner is preferring an appeal to another lawyer. Correct. Now this time, this Swaktam Sarkar, who is appearing, he is appearing. Now, section 5 is there. You have already communicated, Mr. Bari, don't worry. Don't worry.
No, just now.
I know, I know. Your presence, why it has come, and there is no difficulty to get any panic in this regard.
No.
Now it appears that there is a
junior
delay of
Ramya.
129 days. Correct? In the section 5 applications, as it appears from the averments, that there are certain aspersions made on the office, on your office. Now I am correct. What Miss Maiti is saying, I am now office. That there was wrong communication which was made by your office to the petitioner. And for that reason, there was a delay. So there is certain aspersions made against you. my principle is that when a member of the bar is there and there is certain aspersion made against him or her, then he is entitled to be heard. Whether those aspersions are correct or those aspersions are not correct. If we go and condone the delay, then impliedly we are accepting that aspersion to be true against you. So that's why we wanted you to come. What they have said is that this writ petition was disposed of on 1st October 2024. Your clerk made an application on the same day for obtaining the certified copy, which was made ready for delivery on 5th October. Then your office was contacted by the writ petitioner appellate, and it was informed that the order has been passed favorably in his favor. But he did not say that the certified copy has already been obtained on 5th October. And thereafter that the certified copy was handed over, then he came and consulted him, now the advocate, and was advised to file an appeal. So they say that your office made a false communication or a wrong communication. What is your reaction to this? I just wanted to know. Is it true or is it not true?
My lord, may I interrupt?
You were not involved. It is her office who was involved.
No, my lord, he is my junior at that.
Oh,
circuit
I
bench.
understand, but
Yeah.
if she say no,
entire-
we will accept it.
No, it is entire responsibility upon us. Entire office, my lord, I cannot sack responsibility to my junior. So, my lord, so far this statement, as I do not know, I have not been served any copy. I have not seen any Section 5 application.
What
also.
I narrated so clearly.
I believe that is not correct. I believe that is not correct.
If it is not correct, madam, then we will not accept as a ground for delay.
I shall ask my client to remain present before your lordship, my lord.
No, not necessary. Not necessary.
Under what
Not
circumstances, my lord, he
Then,
told me?
No. Then we are directing them to serve you a copy of this application. Make a response.
Yes.
Make a response. No difficulty. Yes. This is an application for condonation of delay of 129 days in preferring the instant appeal. We had an occasion to peruse the averments made in paragraph 3, 4, and 5 of the instant of the said application, wherefrom it appears that certain aspersions have been made upon the advocate on record who appeared for the appellant before the single bench. So, we feel that an opportunity must be given to the said advocate on record to give her response in relation to the aforesaid averments / aspersions made upon her or her office.
Never raise any allegation against the lawyer, my lord.
And therefore direct the appellant to serve the copy of the said application for condonation of delay upon Miss Isha, what? Upon Miss Rinka Chakravarti in course of this week. Liberty is granted to the said Miss Chakravarti to file her response in the form of an affidavit within 2 weeks from the date of the service of the said application. List the matter before the next circuit bench. Yes, call the next.
Item number 99 in this matter, Mr. Navankul Pal is appearing for the state. His mother has died last week.
Same order, next. Hey. Next. Yes.
100.
Following item 100, I appear for the Madrasa Service Commission.
Saying I am agreed by, I am partially agreed by the order passed by the report.
Partially.
Partially, but my interpretation was admitted, but my interpretation has been granted.
Just give us 30 seconds time to go through the order. Yes, that's why we said 30 seconds. Yes, so the interview was already done on January 15, so there is no scope for passing an interim order. What was the interim order you prayed for? Which one?
33.
Page
33.
17.
It is this.
No, where is the interim relief which you prayed in the writ petition before the single bench?
Yes.
Where is that?
Well, no, that is at page 33, prayer F.
That is what I was just thinking. Page 17 is the cost item.
It is wrong. It is page 33, prayer F.
32, I think 31 it starts.
33 is the relevant page.
Is to be qualified. Then B. One post of yes.
Interview is not enough the conclusion of the recruitment process.
What?
Even after the interview happens, there is a counseling that has to happen as per the provision of interview was given in section 16 and 17, and then after the panel is prepared, still the counseling has to be done. So there is still lots of time left. I am challenging lots 2 questions. If the English question paper, if I can satisfy lots of that, then everything would be simple.
Yes.
Because at page 20 is the recruitment notification. Page 20 is the recruitment notification. Oh, in the CAN application, page 36 is the recruitment notification. By way of which the 7th state level selection test was called for. I applied for the test. And notes the question paper was put. The question paper is annexure P3. At page 42.
Well, may I request my learned friend to be little closer to mic?
Please come closer to the mic or open it.
It was switched off. I just
Yes.
Lords, in the instruction sheet.
Yes, now it is clear.
If I can
Now it
have
is clear.
my lordship on serial number 10 of the instructions. It talks about negative marking scheme.
Yes.
It says notes there will be negative marking for wrong choice of option. Only 1 mark will be deducted for every 2 wrong answers. So 0.5 marks will be deducted for every wrong answer. I tentatively, my lord, scored 71.5. Now I have, my lords, I am challenging here 2 questions. One, my lords, is the question number 19, and the second one, my lords, is the question number 29. And I mean, what my challenge is. Before, my lords, I take my lordship to question number 19. If I can have my lords for a moment on question number 20. The difference between question number 20 and question number 19 is that the question number 20 is a very specific question. For example, it says which of the following works
Charles Lamb authored in collaboration with Sister Mary. So it has to be one amongst the 4 answers. And that typically would be a correct answer. Because under collaboration, there would be a specific answer that has to be given. But when it comes to question number 19, there is a problem. The question number 19 says, Charles Lamb's Dream Children is notable for its humor, crushing tragedy, whimsical pathos, or cynicism.
Very specific.
No, my lords, it is not specific.
Why?
In my humble submission. The reason because is, my lords, this story, my lords, Dream Children is actually a collection of an essay. Now, generally, my lords, when we refer to essay, we say that essays has to be non-fictional. But this one is a fictional essay, which talks about a lost love. It talks about the killing of the children by an uncle. It also has an element of humor involved in it. And I am specifically referring to a couple of books, my lords. If I can have my lordship, I will show my lordship that all the 4 answers are correct. If I can have my lordship for a moment,
Yes.
for example, on my lord's on an excerpt that has been taken
yes.
at page 75.
Mr.
My lordship.
Please tell me,
My lordship.
is the court an expert academician? Is the court an expert who knows everything, even in academics? Can the court go into, how far the court can go into all these aspects?
My lordship. I understand.
There is a direct judgment of the larger bench on this.
Yes?
There is a direct judgment of the larger bench of the Honorable Supreme Court.
No, even a Supreme Court judgment is also there.
No, there is a direct judgment saying it is not for the court. And once the subject expert decides a particular final key answer, it is not for the court to decide whether that is right or wrong.
Nowadays, the
Elaborately
expression has
discussed.
changed. Nowadays, the expression is changed. Is a domain expert,
Yes, yes, domain expert.
not a
Yes.
subject expert.
Yes, yes. Namala, I can give the reference also. And in any case, my lord, lordship is not going to hear the merit of the matter because the affidavits have to be exchanged.
That might not be required, my lords. If I can have my lordship for a moment on page 75, which is an excerpt that has been taken from lords the guide of
Sir, many authors, they look at the thing from their own perspective.
own perspective. Yes, that's what I am trying to point on, my lords.
Now
And
I'm
that
saying,
being true-
then in that event, if the expert has adopted or which is taught a correct principle or a one particular notion, then it is the expert who has to be respected, the court will not. One thing can be looked from a various perceptions. So now we are live, I can give you multiple examples of a author's creation which can be looked into from a different angle.
perspective by different person.
Yes.
Perfect.
True.
No, remember, what I'm
So in
saying,
that
lords, is-
event, if the particular the book
my lordship,
which is taught by the different colleges or the schools or whatever, which is a prescribed book, if they have said that this is what is the correct one, then in that event, one has to accept it
my lordship.
and to be correct, even if there are many opinions or views other than that. Now, at this stage, we are concerned with the interim order. What interim order to keep one
Yes.
post vacant?
There are 4 answers.
That for that reason, that suppose of ultimately if you lose, well, who will compensate the other rightful candidate who otherwise was entitled to be appointed to that post? Who will?
No, lords, there is always a wait list along with the panel that is
No,
prepared.
sir, you do not know. The qualifying service will be disrupted. He will lose that particular 2-3 years at the time when he received or attained the superannuation. If that duration is less than 10 years or a 15 years or a 20 years, then are you not depriving him?
Lords, if my challenge to the question is accepted,
Then I'm saying if
Then
it is,
my right
if you
was-
do not, if you could not succeed, then what? One has to give a balance. It's an equilibrium, equity that should play while passing an interim order. There are high probability and there are less probability. One has to understand. I do
I need to
not
place
think
my
in
case
an
in the high
academic
probability-
side,
in the high
in an
probability zone.
academic side, I have doubts. I have doubts.
Just two references, my lords,
sorry.
and I will be there.
Sorry.
If I can have, my lordship, from the question. I
Are
have
they,
four
are
answers.
they duly recognized by
Yes,
the
yes,
colleges?
Yes, yes, yes.
Those books are taught in the college?
Yes, my lord.
particularly
And
the
I will
English
show
subject?
to my lordship that all the four answers are correct. If I can have, my lordship, for a moment on page 75.
Yes.
The first answer at page 19, my lords, was humor.
What?
In the multiple choice question, my lord, the first answer is humor.
What?
In
Where
question
do I
number
get it?
19,
Yes.
the first option is humor.
Yes.
Now, as per 59, my lords, question number 2, if the answer to question number 2 is looked into, in
What?
dream children, in
Yes.
page 75, my lords,
Yes.
sorry. In dream children, the tenderest pathos and the sweetest humor. So humor is also correct.
What?
The answer to question number 2, my lords, the opening line. Then the second option, my lords, crushing tragedy. Even tragedy is correct. That would be evident from the answer to question number 5.
What is this extract? From where you got it?
My lords,
What is this? The
page
reviews?
74, page 74 is the
What
the
is
name
this
of the-
reviews guide to SLST
my lordship.
English? What is the authenticity of this? This Khatwa and Khatwa?
No issues, my lords. If I can have, my lordship, for a moment on page 73 then.
What is this Khatwa and Khatwa has this?
Page 73, my lords.
Yes.
Again, same issue there. Question
No.
number 8.
From
the
where? This is a reverie.
This is a reverie, a deity.
So how can it be?
Now, no, it's something like this, my lords.
No,
If-
no, I am talking about particularly, I am talking about a particular book which is prescribed by the university, prescribed by the UGC or what? I just wanted to know if the answer has been given there. I think that should be accepted as an answer, unless it appears to be absolutely absurd. There are large number of things which is happening globally.
Lords, the problem is with this question itself.
How can
The
we?
question is vague.
No, not vague.
Question is
It's
vague,
not
my
vague.
lords.
It's not vague.
All the three answers are correct,
Yes.
and all the three answers are correct from the same my lords reference.
I believe that that should not, that will bring that everybody who has attempted this question or the person who did not attempt this question, everybody should be given a uniform marks.
Has to be, my lords.
And
Uniform,
the same will happen.
Then it will be again the
In fact,
why,
my lords,
why? Everybody,
the
somebody may not attempt finding it, it's an ambiguous question, may
That is
not
what-
attempt, then they cannot be faulted with. Somebody has attempted A, somebody may be B, somebody may be C, then everybody has to be
even
getting
they
uniform
have
marks.
also checked their sample answers.
So in that event, if everybody is
For
provided a
questions.
uniform mark,
Same
what
difference.
do you have?
For instance, my lords, question
What do you
number
have?
29.
Then you stand in the same position, that of the one who is higher in position.
The final marks will come down, lords, for everybody.
No.
Qualifying marks will come down.
No. Everybody will be allotted a mark.
Instead of 100, the exam will be of 99 then.
No, definitely not.
Or everybody will be allotted the mark.
That is what I'm saying. So they stand on the same footing. If you have got say 70, you will get 72. Somebody who has got 74 will get a 76.
Difference will be the same.
Difference would remain the same too.
There is a second question, lord, that has question number 29, lord.
So we can't. You go and file the affidavit. Let the court decide. Whatever. If you ultimately
By the
win,
time the
no
writ petition
difficulty.
will be decided,
No,
my relief
no.
would become infructuous.
No. We will request that the application should be given a primacy. File your affidavit immediately.
Yes.
File your affidavit immediately.
My lordship.
Give that reference of the special bench.
Yes, my lord. This is 2000. It's a larger bench. 2021 to SCC 309. And paragraph
2021 to SCC.
to SCC 309. It's
That
a
is what I
three-judge.
said. The Supreme Court judgment. I am aware of that.
And my lord, there are three paragraphs. Paragraph 15,
Paragraph
paragraph 15,
16,
1-5. No, 15, my lord. 15.
1-5, yes,
Thereafter 16 and
Yes.
17. And this judgment relied, my lord, a old judgment that was that Ranvijay's case 2018 to SCC 357. That was the very well-known judgment in the field.
yes, 2018,
To SCC 357. And they are exactly what Lordship has held. There could be multiple interpretations. In Ranvijay, the Honorable Supreme Court ultimately held, even if there are multiple interpretations, the presumptions that is a domain expert, that's the language Lordship has referred, that has to be presumed to be right.
that should be the correct way.
And the reference was made,
They,
otherwise
they
what
can,
will
my
happen
lords,
in public
along with their
examinations.
affidavit, they can file the expert opinion as well. That's it.
Why?
No, in
Why
the
they
writ
should?
court, when they file
No.
their affidavit, let the expert opinion also be there.
Since he is appearing on virtual mode, I can't make something. I can't give you more
No, Lord,
example.
the writ is already pending.
More example, I cannot give you. Otherwise, I would have given you more example for this. It's only because he is appearing virtually. I am not going to say anything on that. Come. উনি তো থাকবেন ডিকটেশন ইন প্রগ্রেস
ওনাকে রেখে
Appearing for Madrasa Commission.
Yes, my lord, I'm appearing for the Madrasa Commission. My lord, along with me, Miss Madhurima Sarkar is also appearing.
Mr. Dor, the
She's-
learned advocate, appearing for the Madrasa. the Madrasa Commission to file their affidavit in opposition within a week from date. Not 2 weeks, 1 week. Within a week from date, reply, if any, shall be filed within
2 days.
within 3 days therefrom. Let this matter be listed immediately on the commencement of the next circuit as a specially fixed matter to be taken up, as a specially fixed matter
Before the writ court.
before the writ court, before the single bench.
I am deeply obliged.
Deeply obliged.
Yes. The appeal and applications are disposed of. Next. 101.
101, my lord, I am appearing for the appellant.
Yes.
I am appearing for the appellant. This group 4 GST matter, my lord. With greatest respect, my lord, learned single judge admitted the repetition and gave direction for exchange of evidence and stated the observation in 2 parts. In first part, my lord, the statutory appeal rejected on the ground of delay, and my lord, 170 days delayed after the
Yellow. Yes.
my lord. In the first observation, my lord, there was delay in the part of appeal, my lord, and appeal ground rejected on the ground of limitation. And my lord, we relied our division bench judgment, my lord, in the case of SK Chakraborty, that held that Section 5 Limitation Act is applicable while filing of appeal in GST. And against that judgment, my lord, state filed SLP and SLP state, and relying on that judgment, Honorable Single Judge stated that our division bench judgment is suspended animation. This is the first. In the second part, my lord, there is violation of natural justice because I prayed adjournment. That adjournment was not given. And also, my lord, in the show cause notice, the personal hearing column mentioned that.
Now tell me if the appeal is the remedy which is provided against an order.
Yes, my lord.
You preferred an appeal.
Yes.
With the Section 5 application because it was belated one.
Yes, my lord.
The appellate authority rejected the application, saying that they cannot.
They have no power to delay as per them.
Now the question that arises that against that you have come in the writ.
Writ court, my lord, because there is no tribunal.
If the appellate court is not conferred a power to condone delay beyond a certain limit, or there is no power to condone delay, whether the writ court can direct the authority to do a thing which is forbidden in law,
that is, my lord,
or not conferred in law. I'm just asking.
Yes, my lord. My lord, respectful submission is that, my lord, our honorable division bench in the case of SK Chakraborty categorically.
I understand that held that Section 5 is applicable in such appeal.
Yes, my lord.
Section 5 to what extent? I do not know which provision you are referring, the appellate provision where the power of condonation is restricted up to a certain date, a period, or beyond that.
3 plus 1 month. 3 months is the limitation period, 1 month can be extended.
Outer. Does it contain that the appellate forum cannot condone the delay beyond that?
That is not an.
There is no.
Or outer cap is given that beyond 1 month?
Yes, my lord.
Up to 1 month. Let us see.
Yes, my lord. Section 107, my lord, GST Act.
Yes, show us the GST Act. Ache ekhane?
আমি তো একটা বই এসেছি
Give another. Ache.
Understood. Well, I'm giving another.
No, we got the book. 107.
Yes, madam.
Yes.
May I read, my lord?
No.
Appeal to
May be prescribed within 3 months from the date.
Yes, madam.
On which the decision is communicated.
This is the first, my lord. May I read, my lord?
No, I have already read.
And my lord, the 4, my lord, subsection. The appellate authority if he satisfied that the appellant was prevented by sufficient court from presenting appeal within the prescribed, within the aforesaid period of 3 months or 6 months, for 6 months for department, or for 3 months, as case may be, allowed to the presented appeal further period of 1 month. Thereafter, it is not mentioned. That is why our division bench, my lord, held that no, the appellate authority has the power to condone the delay, my lord. I am carrying, my lord, that judgment also.
Financial, the strict intervention must be there. Principles of intervention is concerned.
No, I'm gonna go to the fiscal statute. The interpretation which you know to the benefit of the necessary or trivial also. And again, what the period of 1 month to the correction.
That is the outer limit actually.
Where is the judgment of Justice
Yes.
Mohit Shah of the Gujarat High Court?
My lord, the delay condonation, my lord. That I am not carrying. I am carrying, my lord, our division bench.
I am asking you,
Yes,
there
madam.
was a very unique judgment that has been passed. It says that the statutory authority may not have the power to condone the delay beyond a certain limit. But 226 court is not fettered with that. 226 the court can condone. I'm in your favor.
Yes, my lord, I am not carrying on the judgment, my lord.
Being that
Unique judgment of its kind, I'm telling you.
Yes, yes, yeah. I am noting, my lord.
Of Justice Mohit Shah. Was from an income tax appeal.
I will check, my lord.
The CIT appeal does not have a power beyond that condonation.
I will check, my lord.
Statutory authority doesn't have any provision to go beyond the 3+1.
That is
That is
what
the
I
problem.
gave. There the Justice Shah says that why not, the writ court can.
But in the recent judgment in Delhi High Court, Lordship, this specific matter has been discussed in vastly. Various of writ petition that has been come on the basis of the 107. I would like to. 2025 March, very recently. The relevant analysis and decision from paragraph 58. Yeah, read Lordship.
No. What to do?
My lord, I have other submission also, my lord. Regarding this suspended animation, my lord, that was only state, that also not pronounced any final order. So, my lord, SK Chakraborty order is still binding on us, my lord. And also our division bench in case of Piyush Kanti Chaudhary, my lord, your lordship knows, my lord, that until the final order comes, my lord.
No, section 5 may be applicable.
Applicable, my lord.
But not a question. The question is, suppose if the section 5 is applicable. But if the power to condone the delay is restricted, then whether taking advantage of section 5, unlimited powers can be given. That's the question. Say now we are taking a example of a civil matter. Section 34 of the arbitration and conciliation, where the time limit is provided within the statute, with an outer cap that beyond that the court should not condone. Section 5 is applicable to a court, but the condonation beyond the outer cap cannot be done.
That the language thereafter not mentioned in the
Is there. Now the language is further. The word further, which is used in the subsection 4, has to be construed and understood in that perspective. Further means what?
My lord, may I submit our division bench judgment, my lord?
This is what I'm saying, whether this was considered.
And submit.
What is the meaning of the word further? It simply says when there is no outer cap, there is no language which says that beyond it cannot be done. So it is directory in nature.
Copy. My lord, para 19 onwards, my lord. And also, I will show, my lord, another judgment that our division bench also condone the delay, my lord. Our Honorable Chief Justice. Para 19 onwards.
No, I have a different notion. That is not provided in it. And that was not a correct approach of doing that. The question was something different. You can bring that judgment, that's all. If you can find out that judgment of Justice Emerson.
I will carry, my lord. And here, my lord, I have.
That's the only rescue for you. Otherwise, I
And,
don't think so there is any.
And my lord, second submission, my lord. That, my lord, in the statute state says that when adverse decision, there is adverse decision, personal hearing is mandatory. Our division bench, my lord, held that even I request not submit a request for personal hearing.
That goes into the merit.
Yes, my lord, merit.
But you have to cross the initial barrier.
Initial barrier, right.
Once it is condoned, then it is regularized, then you can take all those plea in that appeal, but you have to cross that hurdle of limitation.
But my lord, subject to correction, my lord, when the show cause notice issued, I prayed adjournment. Law says at least 3 opportunity.
I understand.
And my lord, personal hearing is a question of law, my lord.
I understand, but can you raise that plea? I'm again asking you.
No, I missed that verse, but
So-
my lord, my lord.
So what to do? First you cross the hurdle of limitation. The authority says I do not have now the jurisdiction to entertain the appeal because of the delay having been committed. I will not go into the merit.
Right.
So
And my lord, another aspect is that, my lord, while issuing a show cause notice, I am registered in the West Bengal. They have taken.
again, it's a question of
Yes,
merit.
this is the question of
But
merit.
I'm asking you the question, first you cross the hurdle of limitation,
Yes.
because if I have to take, then I have to take a dissenting view to this.
No, I'm praying for the next circuit. My lord. I will return.
No,
to the-
not, sorry, this is not, because I express my mind, that really gives you an encouragement to ask for an adjournment.
No, there-
I should have kept mum and then do whatever I felt. Is it a correct way or fairness to be shown in a dispensation of justice?
No.
We should have an exchange on the proposition of law. I may be wrong. I will correct myself. That's the role of the lawyer, to assist the court.
I will carry, my lord. But not-
Bring that. We can't do it because I have seen the order, as the case may allow to be presented within further period of 1 month.
1 month. That
What is the intention of the legislature to use this word within further period of 1 month?
My lord, may I submit
Does it
our,
not bring an outer cap?
That is the maximum time I can use my discretion power.
my lord, may I submit our honorable Chief Justice one order, my lord?
No, you bring it, otherwise we will not. Then I have to take a dissenting view in this regard.
No, I will bring it. May I submit just for your lordship?
What?
Our honorable.
That's an interim order.
No.
What?
Delay condone, my lord. Our division bench, my lord, honorable Chief Justice condone the delay. Because my medical reason is there, here also medical reason there. From my lord, entire judgment, my lord, from para 3, my lord.
This is what I wanted to say, Justice Amar.
Yes, yes.
Judgment is that
Yes, ma'am.
Article 226 is
Yes.
wide enough.
Wide enough, my lord, wide enough.
You are again going 107 may be barrier. What 226 is not a barrier,
Barrier.
which I gave you an indication.
Yes, ma'am.
Difficulty nowadays is that you do not understand that where the court is heading.
I will get.
I told you this is what a judgment is.
আমি যেটা বললে কনসেপশনটাই দিয়ে দিয়েছেন
Bring tomorrow, bring
Yes, ma'am.
the judgment.
May I submit the affidavit, sir? No.
Not necessary, kalke rekhe do.
My lord, I may be permitted, my lord, tomorrow virtually, my advocate on record will be here.
But there must be all the books which should be
Yes,
here.
yes, books on.
It's tomorrow.
I'm great.
Oh. Now, my brother wants to sit singly. He has many matters.
May I submit your lordship? One matter, that is item number 105. It is appearing in the list since last Monday.
We'll take up tomorrow. We will be starting from 102. Don't worry.
10.
Where we ended, we will start from there.
Good.